written off. Okay, but it has been identified. So to put it that an asset considered as uncollectible and of such little value that is continue as a bankable asset is not warranted, although there may be some salvage. Meaning that recovery possibility is very less. Okay, so most probably it should be accounted as loss. Okay, that's the real position or scenario where the loss assets should be recognized as in that scenario it should be recognized as loss. Okay, so just a moment. Yeah. Now, if you see how to upgrade, let's see about the loan, whichever whatever the loan account classified is NPA, how it can be upgraded. Nothing, simply if it is paid, it is no longer NPA. See, that is the basic logic of entire NPA. Okay, if it is paid, the amount is paid. Okay, the interest and principal are paid by the borrower, then it comes to the normal position. As long as it's not paid, then it's remains the status of NPA. Okay. Now coming to now stress assets, as I was explaining, it is nothing but non-performing assets plus restructured loan plus return of assets. This total we can say stress asset. Let's try to understand NPA what we discussed. What all the assets will be deemed as NPA. Okay.
Sir, can I ask a query?
Sorry.
Can I ask a query?
Yeah, please.
Sir, you said in this slide that if the repayment is done,
Yeah,
then it will come out of the NPA.
supposed to.
I just want to understand few things. Like suppose if the product is a overdraft,
Okay.
if that overdue amount of the interest is paid, then it will come out of the NPA.
Sorry, can you come again? Sorry.
Sir, I'm just talking product wise NPA. Now, suppose if that loan product is a overdraft product.
OD. Okay.
OD.
Okay.
So now overdraft, the charge is of the interest which the banks does usually, right?
Okay.
So if that particular interest amount is paid, whatever that interest amount is overdue,
Okay.
then that particular account will come out of NPA, or is it like the full amount, including the OD limit also? Everything has to be paid
Is
to
that
come out
OD
of
limit
NPA.
is used?
Whatever is used, yeah, whatever OD amount is used,
No, that means the principal is due.
principal is zero.
No. I'm saying the OD, if it is used, that means there is a principal outstanding.
There is a principal outstanding, yes.
Correct. So
Right.
that principal outstanding is due, and the relevant or the related interest also is due. Correct.
Right.
So your point is that whether that also will be taken into non-performing, correct?
Yeah, I mean, how much amount is to be paid to come out of NPA?
No, see, it is a requirement of the bank that the due amount, whatever the bank says that they demands and give the time of 30 days time they will give. Within 30 days, if the company is not paying the due, then bank declares as an NPA. They give a notice to the company that within 30 days an amount has to be paid, whatever the due amount the bank claims. Suppose the company is not accepting the due amount, they can write back and say that how you can say it is not due, I have not withdrawn at all, I have not utilized the overdue amount at all. And then that means OD amount, I have not you utilize the OD, then how can you can demand? So all that can, when it is utilized, then it becomes, see, all the more, it is nothing but the OD is that the amount, instead of taking loan, the OD is as equivalent loan. That you agree, right?
Sir, overdraft is more like a limit, which is given.
Correct.
So whatever which you are overdrawing, whatever you are utilizing, for that portion you are paying the interest.
Credit that available from the bank.
Right.
It available from the bank. That not much different. What I'm trying to say here, cash credit, okay, and whatever the loan you call it or OD, as long as OD is not utilized, then it is not a loan. Because it is OD. The
Yeah,
limit
it is a limit.
it is not utilized. Correct?
Right.
I've seen in few cases where the OD is not utilized, still the bank has demanded. Then we wrote to the bank also. I've seen those cases also where the company has not utilized OD itself, they were demanding certain things. They said that there's a loan outstanding of so much. So then the company wrote back to the bank saying that when OD is not utilized, how we can say? Then the bank was replying saying that no, OD is given to you. So you supposed to utilize, you're not utilized because already the credit limit is blocked for you.
Right.
They were
Right.
taking stand.
Right.
Bank, I'm saying. Okay. See, just because the OD is not utilized, that doesn't mean you're not taking loan. Bank was taking. But always we can say that as long as OD is not utilized, we can't say there's an outstanding. Very simple. If OD is utilized, there's outstanding. If there's outstanding, there's interest. There's accrued, interest keep accruing for the outstanding if it is not repaid. And if the bank demanding from the company fails to pay, naturally it has to fall within the category of NPA.
Okay. So, sir, my question, I understood, like overdraft, how you are interpreting. But now, suppose, sir, if you are talking about a term loan,
Okay.
we are repaying term loan with a EMI.
Okay.
Now, suppose, as per the definition, whatever three EMIs or whatever there are lapses,
Hmm.
the account will come into the NPA fall,
Hmm.
right? So after becoming SMA 012,
Hmm.
now if I want to again bring this account out of NPA,
Hmm.
what will be that amount which I'm supposed to pay? Is it the overdue amount or is it the full amount of the term loan? Because if I pay the full amount of the term loan, then I am paying off the full liability, paying off the full debt itself.
See, I'll try to explain this way. Anyway, I have a lot of RBI circulars to show you. Then you will have a complete idea how it works, the entire method, how it process, how it works. Because all this is designed by Reserve Bank of India.
Right.
All this is designed. Okay, there are a lot of provisions that we need to understand the entire gamut of how it operates. Okay. Anyway, leaving apart, I will take you through all that in the coming slide because I have few circulars
Okay.
of RBI also. You will
We'll discuss
understand.
that.
But before that, I'll just give a single line answer to you. See what I'm trying to say. The NPA, when it become non-performing assets, is nothing but those days I've seen even 20 years back when I was in employment. Okay. I myself, I seen the letters where we got from the bank, where I worked in the company. So bank keep giving chances. It's not, though it says only 30 days time will be given by the bank as per the RBI norms it says, but still bank keep writing many times. Then after a point of time only, this fellow won't pay, will not pay at all. Classify this as NPA so that once it become NPA, they have their own guidelines, how to deal with the account. That they give enough opportunity. I don't think just because of in a matter of 30 days, the company is not paying, they immediately jump and classify NPA because they are not going to gain anything by classifying NPA. You know that, right? After all, they are going to much more damage the account only, lose the account only. So, to my knowledge, my experience, bank give opportunity to make it good, to make the account good. After if the company is not exploring or not utilizing the chances given by the bank, then the bank after a point of time, the bank should also do their duty, their rank card, they should keep their report card clean. Otherwise,
So
the office
that
is
is very,
responsible.
yeah, that is,
Excuse me. Let me say,
Yeah.
if the overdue amount is repaid by the customer, whether it's OD or term loan, account can be upgraded to standard asset.
Yeah, sorry, can be upgraded to
Standard asset.
standard assets, you are telling.
Yes.
See,
Yes.
it is purely with the bank.
No, it's not one bank. It's the rule
What I'm
now.
saying, what I'm
It's as
saying.
per RBI guidelines that you
Oh,
have.
I'll tell you, I'll show you that guideline. That's why I said I will show the guideline. Okay. In fact, that's why I don't want to give full answer now.
Sir,
Hmm.
I understand what this gentleman was saying, because the query here was the
Hmm.
reason being because usually the bank which sends the letter is
Hmm.
the loan recall notice.
Okay.
And when they put a loan recall notice, they are recalling the full amount of the loan. They never talk about the overdue amount at that point of time.
No, full loan, recalling full loan amount means what you mean? For recalling full loan is loan availed, utilized?
Sir, full outstanding, including everything. Because when a bank is sending a notice,
No,
they
that's what.
don't
Full
they talk
outstanding.
they talk about the loan recall notice, totally loan recall.
Okay.
And after that, if we
Hmm.
go and pay the overdue amount, and then
Hmm.
if we ask, the bank to put it to the standard asset,
Hmm.
they say that we have already recalled the full loan.
Hmm.
So the call from the bank is for the full amount of the total loan outstanding.
Okay. Okay.
It's like that only. It's like that only that you are not a good customer, so we don't want to continue
Right,
with you. So you recall
right,
our, we recall.
right.
Okay.
But
Yes.
in any case, the banks are considering the case where if you deposit the overdue amount, then they put it to standard asset.
Okay. Okay. So in all the cases, this is happening, all the cases?
Yes,
No, no,
in all
whatever
the
cases
cases.
you handled, in all the cases it happened like this?
Yes, yes, sir. In
So
OD,
you mean to say the bank is following same way that they are recalling loan in all the cases, there's a default?
yes, if the account becomes NPA, they recall the advance.
That's what, if account become NPA,
Yes,
correct? No. The
yes.
point is here, it has to first become NPA.
Yes, that's true.
Then they will
We are
recall.
talking about NPA only, na, right now.
No, I'm saying, that's
Yeah.
what I'm saying. The NPA, once it become NPA, okay, and that's why I said there's a timeline is given for the company to repay. That's why they are giving the time. If you are not paying, they take their liberty because they have to follow the guideline.
Yes.
And also, what I'm saying, see, there is nothing stop the company at any point of time to question the bank. Okay, and file case against the bank. If they are not following or they are not following the norms of the Reserve Bank of India, it is always open to the company to question. If it is a government bank, we can always take them by filing a rate, and we can do any. There are a lot of avenues there to question the actions of the bank. It doesn't. It's not that simply bank is doing. You must be knowing that. Okay, today the matters are coming under IBC, right?
Yes.
Today we have IBC law. Earlier,
Yes.
what was happening before IBC?
DRT only.
Okay, how many cases are coming? All the cases are coming in DRT. All, whatever the due. Because I myself have a handful experience. If 10 companies are defaulting, hardly one or two only taken to DRT, or maybe two, three or four. Then to 3 or 4, out of 3 or 4, hardly one or two is getting, enforced by. Then the matter is prolonged. Then it is over a period of time, things are completely going in a different direction. So what I'm trying to say, what banks are doing, okay, if they are doing in 1 or 2 cases, by seeing the conduct of the company, they would have taken a stringent action. Otherwise, bank or always they follow slow approach. That's why today the necessity of insolvency code has come. The necessity of insolvency code has come because the government felt the inaction of the I would say bank or in recovery mechanism, whatever that. That's the reason the code itself has come. Otherwise, we don't need a code. If bank would have properly done everything on time and they were strict on the companies and they collected everything back, or if there's a default, they never allowed a company to do anything further to deal with the account. If that level they would have been strict, then we need not.
Actually, DRTs were for recovery only and IBCs for resolution.
Yeah, correct. I understand.
Sir, may I take 1 minute just?
I'm not disputing that. The idea of IBC itself is only for recovery. That also I have to share in a subsequent slide. It is only for recovery, not even liquidation. That liquidation now we are following that because the provision provides for, but object doesn't provide liquidation. even now
Sir,
in
may I take 1 minute, please, sir?
Yeah, please tell.
Sir, actually, there is concept of debt, due, and default.
Okay.
When an amount becomes due, that means suppose 3 installments becomes
Okay.
due,
Okay.
or 1 installment becomes due. 1 installment may be 1,000, but
Okay.
the whole amount of debt becomes in default.
Okay.
So the bank recalls the default amount.
Hmm.
Therefore, we cannot say that after giving the due amount, the account will become NPA and I will continue with the bank. That is
Okay.
because
Okay.
they have recalled the default amount, whole amount.
Hmm.
So that's why that depends on the bank. If there is clause in the agreement that by paying, the borrower has right to continue, then they will continue. Otherwise, if default amount is recalled, the borrower have to pay the recalled amount. Recalled amount is default amount. Due and default are separate, sir.
Okay. So you are telling in what stage? In the initial stage or in a much matured stage or later stage you are telling?
At any stage, suppose there is 2 lakh installment, 2 lakh rupees is not paid. Suppose for that 2 lakh rupees, that is a due amount, that is not paid. For that 2 lakh rupees, bank can declare the whole amount of 1 crore or 2 crore, that is default. And when this amount becomes default, bank can go to NCLT for initiation of CIRP. There we cannot argue that default amount is 2 lakh. No, the due amount is 2 lakh, but the default amount is 2 crore.
Okay. So what I am saying, correct. I understand what you are saying. Okay. See, even if you see section 29A, I think that's why I just want to give a reference on that. 29A subclass C, if you see, though person is not eligible to be a resolution applicant, but again it given a rider, provided that the person shall be eligible to submit a plan if such a person makes the payment of all overdue amounts with interest thereon and charges relating to non-performing account before submission of resolution plan. That means even the IBC itself provides a way out. I'm saying leave it all the bank. The IBT itself provides a way out under class C. If you see the proviso that if you before submitting a resolution plan, if you are repaying the overall due amount, then you become eligible. You are no longer a NPA. That's what the IBC itself endorsed. That see what I was trying to say. Now I got your point. What you both were discussing. See what I was telling about. I started ABC. You both have come to XYZ actually. Okay. I just to give an idea about NPA, I just gave. Okay. Suppose if at all a company is in a position to pay, if it is pay in the initial stage itself, then it comes out. That's what I was trying to say. You have gone to the stage where company, they all defaulted, they have not paid, and the bank after a point of time, they thought, okay, let me recall the loan. Anyway, this fellow is not going to pay. Let me recall the loan. You are talking to that stage. So that's why I asked in which stage I asked, whether it's the initial stage or later stage. In fact, any banker, my own experience, in any banker, they never, in a first instance, jump and recall the loan. They are not doing it. They are giving opportunity because they don't want to lose the account. Any company can. Of course, they have to follow the norms, RBI norms. Within the RBI norms only they are doing, no doubt. But still, bank try to give time to the company to see that, make the account as a performing account. Okay, in the initial time. But after giving an opportunity, if they understand the company conduct, the conduct of the company is not proper, I think the conduct is to, delay or default in the making payment, then bank takes its own call. And of course, there is a guideline. That's what I said. There's a lot of circulars that, in fact, each and everything what we are discussing, everything is spelled out in the circular by Reserve Bank of India. It's not that either we as a professional or bank on their own can do anything. whether to declare NPA or whether to make the account normal, or whether to classify the account as willful defaulter, or refer the matter to IBC. Everything is properly, spelled out by the Reserve Bank of India in every circular. That's why I told you, I'll show you. What you are talking is probably it would have happened few companies, I won't deny. They would have recalled the entire loan amount. Then in that case, it won't be possible when they recall, because they made up their mind that this company is not going to pay in the initial stage itself. Then after waiting a time, they see they have their own rule book to follow. After that, they have to recall the loan. They are recalling. If you ask me that after recalling, it will become normal, no, not at all. Because after that, it goes in a different stage. It goes to the next stage. Then it has to be a recovery proceeding only. What I was telling, this DRT and today IBC, SURFACE and IBC, and before that Provincial Insolvency Act, Presidential Insolvency Act, what I was trying to say that if bank would have been so strict, then introduction of IBC itself, the situation or the requirement would not have come. The bank would have been really that strict. All I am saying that, yes, it will not simply make an account normal just because of you are paying, whatever the loan due. But because they see the stage, which stage it is. If it is in the earlier stage and they give a notice, company makes payment, it makes normal. That's what I was trying to explain to you. Anyway, we have much more to learn about NPA. More than NPA, we have much more to learn in Insolvency Bankruptcy Code, what it says, how it deals with. What we are talking is purely NPA under RBI guide. It is only RBI regulations, and it doesn't nothing to do with the Insolvency Bankruptcy Code. What we are going to discuss, what we are supposed to discuss. But just to give idea, we need to understand all that. Anyway, we'll discuss at the end also. If still you have any doubt, you can put
one question, sir.
Yeah, please.
Sir, you told stress asset is equal to NPH plus restructured loan plus return of assets. But NPA, it becomes after 90 days if the interest and due amount is not paid. If that is not paid after 30 days, then State Bank of India and other banks, I don't know whether other banks do or not, they categorize it as SA1, stress asset 1. Then it is not paid for 60 days, SA2, stress asset 2. Then after 90 days, if it is remains SA2 for next 30 days, after SA2 it remains for next 30 days, that means after 90 days, it will become NPA. So SA1, SA2, these are also stressed assets, what I understand, sir. SA1
I'll
is
show you
if
that.
the interest and due amount is not paid for 30 days.
Hmm.
Though it is not NPA, not restructured loan, not written off, it is also a stressed asset.
Yes, see, this is what I wanted to even wait. In fact, I thought after giving
For such SMA assets, we can also go for CIRP.
CRP only as as long as it fulfills the requirement of IBC code, it's enough. There's a due amount, there's a default, then it can go into CRP. That's all. There is nothing more. You know that, no, that it has to satisfy the requirement of IBC. There's nothing to do with the RBI requirement for triggering insolvency code. So this is what the reason circular which I wanted to discuss. The circular dated June 8, 2023 on compromise settlement and willful defaulter and fraud cases. In fact, in that, if you see, every circular, there's a link is there. This only I thought I should show you in the beginning itself how each and every, the RBI has got directions, has given a direction for each and everything, how each and every asset has to be dealt with. Okay, this is a framework how this only you are trying to tell, right? Correct? No, SMA 1 to 30, SMA 1, 31 to 60. Correct? You are right. This only you are referring. So this is clearly, there's a framework is in place. Now, how the stress assets has to be, categorized and what needs to be done. This only I was telling that, see what I was trying to say, how it became NPA, and here we are not, trying to understand and restructuring how it could be done as per the directions of the Reserve Bank of India. That's why I don't want to go much in deep of that, because our idea is to understand what is the way out that is given under the Insolvency Bankruptcy Code, right? Probably there is another session that way out under RBI regulation, then we can go in deep of this. What are the regulations and how it talks, and what are the avenues available, what are the solutions given by the way outs given by the RBI. All that is much more we can discuss, because so much is there to discuss on that. More, in fact, I would say more than IBC. If you see RBI circular, there is so much to discuss on that, which talks about what is NPA and how NPA should be dealt with, how the stress assets should be dealt with. So these are very important things which we need to understand before proceeding further with the Insolvency Bankruptcy Code. Okay, as you said, these are the stages given. SMA 0 and SMA 1 and 2. Okay, so here another, if you see, after that, even Reserve Bank of India guideline itself, how the resolution plan has to be implemented. There is a clear guidance. This is nothing to do with our insolvency code, the resolution plan given under insolvency code. That's totally is different. But here it totally gives a direction to the bankers how they have to deal with before it come into the insolvency bankruptcy code. Because before coming into the insolvency bankruptcy code, the bankers are in a free hand to deal with the corporate, defaulting corporate in a manner as per by the Reserve Bank of India, which it says, there's a clear prudential framework given for stress assets. What are the resolution, how it should be given, how it should be identified earlier. This only I was referring. I was referring identification in the earlier stage. And if it is in the earlier stage, if the company settles the due, then it comes out of the whole thing in an earlier stage, not the stage when the recall letter is coming. I'm not talking about that stage. So it depends on which stage the default arises. Default also, what I'm saying, the moment that bank demands, and if you are not paying it, default under IBC. Okay, that doesn't mean immediately banks are jumping under IBC. If bank wants to give, they give time, and they follow the norms of the directions of the Reserve Bank of India. Then after a point of time, they take a call, because there's a guideline till what they have to explore as per the Reserve Bank of directions. After exploring all this, then they automatically come back. Automatically they come into the insolvency bankruptcy code, because there is no other way. They have to come to the code only after exploring all the directions of the Reserve Bank of India. Even in Reserve Bank of India, if you see, there's a clear prerogative given how a plan has to be given and how it should be implemented. It's not simply they are permitting each and everything to, getting approved. It's not that. There are a lot of criteria given here. Of course, I wanted to show the circular wherever, the corresponding provisions in my slide. So since the discussion has gone in a different direction, I opened this. Right. Let's see, let's discuss then so that we can, at the end, I think we'll have some idea to much more to deliberate on these aspects. Okay, now coming back to these stress assets. What is stress assets? See, NPA plus structured loan from write-off assets. What is NPA is a stage, one stage, then structuring loan. That's what I was showing. There's a guideline given by Reserve Bank of India in June 2023. Recent guideline. I was keeping in there. See? Yeah. So this is the recent guideline given by the Reserve Bank of India how it should be written off, and how the compromise settlements. See, first of all, they are trying to attempt compromise settlement. There's a settlement and compromise settlement. There's a OTS. OTS settlement. Can anyone participant share the difference of OTS and settlement and compromise settlement? Is there any difference? Is there any difference? OTS, compromise settlement and settlement? Okay, fine. I'll take you through, then I'll deliberate. Probably it will be covered in the slides itself. So restructured loan is nothing but, as I was referring, the asset which got an extended repayment period. That's a restructured loan. That's why I said NPA, restructured loan, then the stage comes writing of assets. Then only if the stages comes only, the assets become stressed assets. Okay. Then only, they're coming within the category of stressed assets, within the basket of stressed assets. Then we have to find out what is the way out, how to bring out the asset outside the stressed one. Okay. Now, return of assets. Nothing but a bank does not count the money borrower owes to it. Here, it's very simple. Whatever the financial statement indicate that the return of loans are compensated through some other way. That means they are writing it off. They will make sure they are trying to recover it in some other way. See, that's the idea of personal guarantee. Filing a case against personal guarantor is nothing but, though in the company accounts but they can't, they will not. That's why they are not writing off. In earlier period, they simply write off. Now they don't do, because anyway personal guarantee is there. They can easily recover the money by filing a case against the promoter and the personal guarantee. These are little data that is provided by Reserve Bank of India. I think much more development has taken place after this. Just a moment. Yes. Now this is the important thing which I thought I should. So now coming to the insolvency bankruptcy code. In fact, that's only I was trying to say. Here we need to understand, try to understand a combined way where how this stress assets, okay, and it has to be addressed, or how it is addressed, or what are the ways which are available under insolvency bankruptcy code, and is that really helpful, or whether we need to tell the government, suggest the government, or some other way, or is that already ways are there which is less explored. So all that we need to understand. Then that's the real idea of the code, and understanding the code in terms of stress assets. The insolvency code, you all know that it came into effect, as I was referring, to address the financial failures of the country. Though earlier that there was SARFAEC, of course, today even now it is there, and there are certain cases still overlapping DRT and IBC, and by orders again clarity is emerging again. The matters are dealt with as per the orders. So, but still, insolvency bankruptcy code is the real purpose of bringing insolvency bankruptcy code is that to address financial failures which was not properly addressed by virtue of debt recovery tribunal, or whatever the agency before that. Even there was a BAFR. So see, they were not able to really give solution on time and required a solution, and recovery rate was very less. That's why the government thought that we should have a consolidated code. That's why it is a code. I think many of us, I always think, even few informations which is coming across, I always surprised why they are trying to accept any other provisions, though 238 override, IBC code specifically override, but still there is a confusion there. In few cases, still we come across certain confused interpretation where they say that no, the respective law has to be followed. I think it is a code. You must be appreciating the power of the code. Why it is a code? First, we need to understand. It can be a law. I think the participants here, by now you would have understood why it is not the law, why it is a code. Do you feel that it really serving the purpose by coding and codifying it as a code, or by calling it as a code? Really, it's for serve the purpose today? Is it getting implemented as code or any other law? Can you share your experience on this? Or do you have any different opinion that whether Insolvency Bankruptcy Code, why not it is Insolvency Bankruptcy Act 2016? Why it is Insolvency Bankruptcy Code 2016? Any idea on that? Because if we understand this only, we can really understand the real intention of the law. Is there any subtle difference between the both? Insolvency Bankruptcy Act 2016? Why not? It is Insolvency Bankruptcy Act 2016. Why it is Insolvency Bankruptcy Code 2016? Why it's supposed to be? Can I have answer for this? Because more we are dealing with the financial thing, but of course it is more important to understand the legal impact and real authority that we have by means of in terms of Insolvency Bankruptcy Code. Have we really understood, everyone? I think government must have understood, that's why they brought it as a code. Whether everyone has understood in the same way, are we moving with the same understanding? Why the government has brought it as a code, not as an act? Because SARFAESI there is act, correct? Provincial Insolvency Act, Presidential Insolvency Act. You call any other act, RBI is an act, Companies Act, Income Tax Act. Why this alone code? I think we need to really understand this. There is no input. There is no input because this has more impact. That's why I wanted to understand from you. Are we really understood the real impact of that code? No. So if it is on other 24 participants. Okay. Okay. So I will share because anyway, you will share if something comes in the screen which does not reflect your view, then you will share your view. That means if you are keeping quiet, I have to presume that you are in agreement with you as long as you are keeping quiet. Okay. I will tell you this. Why I am emphasizing more on this code. See, what we were discussing about the regulations. Reserve Bank of India brought so many regulations, and there is a SARFAESI Act and DRT Act and Provincial Insolvency Act, Presidential Insolvency Act, and BAFR, SICA Act. And so many acts are there, and Companies Act, and you must be handling more in winding up in Companies Act earlier in 1956 Act. Even 2013 Acts also, we would have handled more of winding up. Of course, it is only a winding up, not resolution. As one of our friends said, it only contemplates or it only targets, aims winding up, closing the company, not for reviving the company. So government, after seeing all these acts, okay, they felt that there is a law which there are laws in our country to recover and revive. Yeah, of course, there was a law called SIC Industrial. You all know that SICA is there. There's only law which was trying to, through BAFR, revive the SIC companies. There was only law, not much law. Other laws are only trying to recover, okay, not for revival. So then government felt, why there is no law for, say, strong law for revival? So that's why they felt that, okay, by bringing one particular law called Insolvency Bankruptcy Code. Today I wonder, Insolvency Bankruptcy Code sometimes take a backseat. I said, why? I really fail to understand. Sometimes why it's taking a back seat. Then why it should be a code? It can be a law. It can be any other law. Then always we can interpret which law is important, whether that particular law is important or insolvency law is important. Then, at least there is a logic or reason, rational, by interpreting, okay, which law is more important. But the government is very particularly brought it as a code. I don't know why still confusion emerges in our country in various aspects, which you must also be coming across those confusions or interpretations given in at various time by various person. Okay, that no that laws that for this purpose this particular law is. So the purpose of bringing is code to give one-stop solution. That means it is nothing but a guiding force for the entire financial failures of the country. They want to address, because this is see, generally if you see the Companies Act and Income Tax Act are regulating law. It regulate. In fact, to some extent, Income Tax Act also is we can say it as a economy, for reformation law. We can segregate certain laws as regulatory, certain laws are for economic reforms. Okay, even FEMA, not fully regulatory, it is for economic reform. Same way Income Tax Act. Companies Act, it is almost fully regulating. Like, see, if you see Insolvency Bankruptcy Code, it is purely on a regulatory aspects, not on regulatory aspect, purely on a policy aspects. Though regulatory as part of it, but purely on a policy aspects. Because they want to address entire financial failures in our country, which they are not able to, which affects the economy of our country. So it's not, we can simply talk about NPA, bankers, this, that, all that. No, we have to see on the whole. It affects the economy. That's why government felt it. No, now let us, now enough. There's a time over. Now we have to bring out one particular, one law, which really gives solution for entire financial failure of country. And there should not be any other provision that should unnecessarily bring confusion to the Insolvency Bankruptcy Code. So that's why it is brought as a code, not as a law. What I would say, the code is much more bigger than the law, much more powerful than a law. The code is much more powerful than a law because it's a guiding force. That's why today we have, of course, the government is proposing change the name, all that. That's different. Now today we have an Indian Penal Code. It's not directly, bringing into effect. It's not directly brought into effect. How? Through a criminal procedure code, it is brought into effect. All our criminal legislation, through criminal code only it is brought into effect. All our civil legislation, through civil procedure code only brought into effect. Can you conduct or can you do any case? Can you handle any case without following the process of civil procedure code in our country? Can you handle any criminal cases without following criminal procedure code in the country? Though there is a separate Indian Penal Code and there's lot of criminal legislations are there, and every legislation has got a criminal prosecution, punishment. Then too, why we need to follow criminal procedure code? Because it is a guiding force. Because there's a process. The code has prescribed what are the process to be followed to make sure that the particular thing has to be decided. So here we need to understand why something in our country should be brought as a code, not as a law. Then it's supposed to be criminal procedure law, civil procedure law. Why it is a code? Because it is a guiding force. Similar way, Insolvency Bankruptcy Code, guiding force. We need to understand what may be the other regulation the RBI may come out, or any other department may come out, or any other law may come out. That's why the code specifically incorporated a provision called 238, which overrides all other acts. More than that, what we can say? Because a law cannot override another law. See, that is the reason it brought as a code. That is the main reason. And what else other? By bringing one law, you can't amend another law. It has to undergo a parliamentary process. So government felt it. Let's not confuse the entire thing. By bringing one law, simultaneously by introducing one particular code, the related inconsistent provision in any other law should get amended, should stand amended. So, see, that's why the entire provision is provided right from section 245 to 255. All 11 schedules are there, where by introduction of code, all those acts are stand amended simultaneously. That's why it is brought as code. So what I am trying to say here, why it is brought as a code? Let's not try to confuse. Reserve Bank of India regulation says this, and SAFIC says this. No, here the code is a complete code. It is a guiding force for the entire regulation and law and rules in our country, which is governing the financial failures, which is governing the providing a revival and resolution process to the financial failure. So let's have this understanding that the Insolvency Bankruptcy Code is a code which provides a complete, which attempt to provide complete, whether it's providing today, that's different. And it's hardly 7 years old law. Okay. We know that Companies Act after 65 years practice, 1956 Act, government took decision, no, this law no longer gives real solution to our corporates to the country or in regulating a corporate in our country. So immediately they brought Companies Act 2013 after 65 years. So like that, this Insolvency Bankruptcy Code also should emerge. It is emerging. It's an emerging law. But as a professional, we only should see that we are escalating, we are highlighting, we are communicating our difficulties or whatever the way outs that we feel deem and proper, or whatever we feel that is workable in a present scenario, because we are having a field experience than department or any other. Okay, so we are in a better position to see how this law can further evolve, to see that we are getting proper solution to address the stress assets. And the stress assets nothing but the company corporate debtor, which we deal under Insolvency Bankruptcy Code. See, this is the real purpose where today we are sitting at to find out what are the way out, what are the resolution that are available today for the stress assets meaning that the corporate debtor. The stress assets is nothing but is a corporate debtor. What we say as a stress assets is nothing but stress assets in the corporate debtor. Now coming to the Insolvency Code and SAFIC, as I was telling, see, there is one more new initiative the government has brought, which I wanted to tell you. I don't know, have you, anyone here has dealt with the National Assets Reconstruction Company? NARCL? Have any idea about that? Indian Debt Resolution Company? IDRCL? NARCL? Any idea about? Anyone has dealt with that company? Or had an opportunity to know about this company? And what is the role played by this company? No?
I think this is only to purchase stressed assets of banks, big assets.
Okay. So, is it working well? Is it really giving?
It's still upcoming. Only some accounts have been transferred to this company till now, and they are in process of procuring more accounts. Process is going on.
So, that means the government is trying to bring some method, right? To see that how the stress assets can be dealt with. That's one initiative is this National Assets Reconstruction Company Limited. As you said, it is coming up. It has to really work more, actually. It has to, now only recently it has come and started doing, but still it's not really fully come into brought into effect. But it's slowly doing, probably over a period of time, it will come into its benchmark. Probably we'll try to understand what it says. So just to recapitulate, if you see 1985, Sikh Industrial Company Special Act. Then again, if you see 1993, there's a recovery of debt dues to Bank and Financial Institution Act, DRT. Then Corporate Restructuring Mechanism in 2001 and 2002 SARFAESI Act. And again, you see in 2014, RBI has given no asset classification and how joint lending and forum, corrective action, all that is can be, dealt with. 2015 strategic debt restructuring scheme, SDR we call it, and 16 it came scheme of sustainable restructuring, and insolvency bankruptcy code. Then 19 again prudential framework or such as. So all these are the initiatives that really the government is trying to bring out to see that how the stress assets should be dealt with. Okay, and also if you see the compromise settlement, the Reserve Bank of India has not only stopped with by giving directions on dealing with the stress assets or bad debts or NPAs, and they also how to deal with the willful default cases and fraud cases. That means everything the Reserve Bank of India has brought out and they're giving they brought out a directions to the bankers and how to deal with the willful defaulter and fraud cases. In fact, even the RBI has advised, Indian Bankers Association, provide its letters that they can enter into a compromise settlement with the willful defaulter. Of course, there's a separate direction is there how to deal with the defaulters and willful default cases. The circular what I showed, it has got a link. How to deal with the willful defaulter and how to deal with the fraudulent borrower and what are the criteria, what are the conditions that are applicable to them. And once they are classified as a willful defaulter and how they are placed and what are the position, what are the recognitions that are given to them the moment they are reckoned as a willful defaulter. Everything is properly came out with a direction by means of a direction from Reserve Bank of India. In fact, they clearly came out with how to bring out a compromise settlement. There's a settlement and one time. See, the one time nothing but OTS is nothing but is an one-time settlement. That means only cash is involved. That means you settle by cash. Means of settle by an not other than cash. We have to put it this way. OTS is settled only by means of an amount, not other than cash. Okay. In case of settlement, it can happen even through an other than compromise settlement, other than cash. That's why you can see many settlement, many matters compromise, and courts are approving settlement by means of issue of debentures, by means of, in few cases I've seen issue of capitals, and in many cases different form is getting settled by means of a scheme under section 230. I'll detail explain you in subsequent slides how those things are happening also. So if you see there's a master circular how to deal with willful defaulters in July 1, 2015, which envisages the lenders agreeing to compromise settlement with the borrower, how to do that and how to report to credit information companies. That means when the borrower fully make payment to the compromise amount, how to deal with the borrower and how to deal with that cases, how to report those cases. All these things are, as the Reserve Bank of India has given a proper direction and by means of an, clarification or by means of a direction, by means of a circular. See, again, if you see master direction on fraud, it provides for compromise settlement with the borrower classified as fraud. In fact, there's a very clear, information given by the direction given by Reserve Bank of India. No compromise settlement involving fraudulent borrower is allowed unless conditions stipulate that criminal complaint will be continued. So that means it's not that simply something you want to resolve. That means bringing them out of the prosecution. No, cannot be. That's why the Reserve Bank of India clearly by means of a direction issued in July 2000 made it clear that though compromise settlement will take place, but criminal complaint will That's why if you see even in IBC, the courts are, there are orders are there which says that criminal complaint will lie on the promoter irrespective of the matters are pending before tribunals under insolvency court. I think we can give a short break, 5-10 minutes. We'll meet again. Madam, are you there? Okay, I think madam is not there. I think we'll break for 5-10 minutes. We'll again continue after 10 minutes. Shall we start again? Okay.
Yes, sir. We
Yes,
can
sir.
start.
Yes, coming to a national reconstruction company. Am I audible to you? Can anyone confirm?
Yes, sir.
Yes.
Yes.
Audible.
Am I audible?
Yes, audible.
Am I audible?
Yeah, audible.
Anjali madam, am I audible?
Yes, sir. You are audible.
I think you are not getting voice.
Sorry, I was kept my. Okay. Am I audible?
Yes, you are audible.
Yeah, yeah.
Yes, sir. Yes, sir.
Yeah. Okay. Now I reduced my sound.
Volume.
Yeah,
Right.
voice, so I didn't get what you answered.
Right.
Sorry. Okay. Yes. So coming to yes. Mm. So this only we were talking about National Asset Reconstruction Company Limited. In fact, government, central government, they given a guarantee of 30,600 crores to back securities issued by. See, this is the really very good initiative by our government. In fact, they are trying to do their best. Still, things are not improving. That's different. But still, they have even formed a company for this purpose. In fact, the idea of forming this NARCL, NARCL, is to acquire some success about 2 lakh crores. It's not a small value. Okay. And by issuing a security, receipts they will acquire. And of course, it intends to acquire by cash 15%. It will be through a cash and 85% through security receipts. So this is going to be, in fact, as one of our friends said, it is working, but still we need to wait and see, much more. I think in future they will do more recovery or in the form of acquiring and reviving the sick companies or companies which are under debt burden. In fact, this NARCL has been incorporated under Companies Act, and they took license of Reserve Bank of India and the ARC company. It's another ARC company, but there's a difference between other ARCs and NARCL. Do you have any idea about ARC, what they do? And ARC company, the end of the day, ARC company, whether it's formed by, it's run by a private person, people, for the profit motive or for the government. That's make all the difference. Okay. Here, NARCL is to make sure that it is reviving or it is giving an another avenue for revival of the company. The government has took an initiative to form this company. Same way, if you see, NARCL has been set by the banks to aggregate consolidated success for subsequent session. In fact, public sector bank will maintain 51% ownership in the NARCL. So remaining will be in other than the public sector bank. Same way, there is another IDSL is also a service company and operational entity which will manage the asset and engage the market professional. So that means the investment will be done by the NARCL and the management will be done by appointing the marketing professions and other and to turn around expert. That will be done by IDRCL. So this also public sector company, banks will hold in that 49%, not 51%. Whereas in NARCL, the public sector bank will hold 51%. So it will be operated by almost like in a government, and by like a government company. But IDSL will be operated by 49% by government, by public sector banks. So that's the difference between these two. So if you see, we have a 28 ARC already. The question comes, as I was putting to you, why this again and another ARC NARCL and again another IDRC company. So all the here the existing ARC, if you see, they are helping in resolution stress assets, but for a smaller loan value actually, not in a bigger level any ARC is doing. Okay, so now if you see this company, as I was referring, they are targeting 2 lakh crores. So it's a bigger value. The number is big, in terms of providing resolution to the stress assets. Same way, if you see, so NPA, as you know that our country, we have lakhs of crores that are stress assets that has to be revived. That means then government has to take this kind of initiative. Otherwise, it will be difficult to revive the stress asset. That's the idea. The government formed a NARCL. In fact, here government guarantee will be invoked to cover shortfall between the amount realized from the underlying assets and the face value of the securities issued for that asset. So, but how they have a overall ceiling of 30,000 crores, 30,600 crores, which is valid for 5 years. Another here important thing that there shall be a pool of assets. It is expected to realize. So I think they can able to match the flow. So they need to have a flow. So they have to realize also to see that the flow is matched. If you see how timely resolution can be given, because if you see Government of India guarantee is valid for 5 years. Okay, and that's a condition precedent for invocation will be the resolution or liquidation. This is the only two way where the fund flow can happen or the recovery can happen. But to decide the delay in it has to pay the guarantee fee, which will increase passage of time. So that means there's no other way. The company has to revive, the resolution has to be provided, either even in the liquidation, it has to be provided. Then only the purpose of NARCL, okay, the formation of NARCL, and that will be achieved. If no recovery takes place, no resolution is given in the form of selling the assets or marketing the assets, then it won't have, because it has a cap actually. So capitalization of NARCL would be through equity from banks and NBFC companies. So through that funding only, they can able to generate fund. It will raise debt also if required. So Government of India will guarantee and will reduce the upfront capitalization requirement also on this. So another important, what are the resolution provided? What is the strategy that's being adopted by NARCL? Is intended to resolve a stress loan assets above 500 crores, each amounting to 2 lakh crores. That means their focus, main focus, because as I was explaining to you, there are a lot of ARCs are there. For this particular NARCL, their motive is to see that they are trying to resolve the stress loans above 500 crores. So that means anyway they have a cap, they have a target of 2 lakh crores to target. So that means they have a phase by phase they will implement. So first phase they will fully provision the assets about 90,000 crores. So it will be transferred to NARCL. Then remaining, it will be transferred in the second phase. This is the methodology they are planning to follow. Let's see now difference how it works, IBC and SARFAESI. We were already, I was giving few points on that, why this IBC code and how it operates with respect to SARFAESI and DRT Act and other laws. So SARFAESI, as you know, that it's a maximum of 1 to 2 years, but in a practical sense, it's taking some time. Some cases where I've seen 3-4 years, some cases even 7-8 years also is taking SARFAESI. But still, SARFAESI is not providing entire solution. It is only a recovery. it is not attempting to revive. Whereas IBC is purely on revival only. Failure of that only, it goes into liquidation. So here, insolvency code provides a real, insolvency resolution process, recovery process. In fact, after company files a insolvency proceeding or company or bank, that depends on which section it is getting filed. If it is a financial data section 7 and operation is a 9, and if it is by corporate data on its own under section 10. And the personal guarantee, as you know, section 94 and 95. That's different altogether. But here, CARP process can be initiated only under section 7, 9, and 10. So even if you see Honorable NCLAT, it related the effect of the IBC over SARFAESI. Even Supreme Court in many cases, they emphasize the role of IBC than any other provisions of the laws of our land. In fact, section 238 of IBC, as I was referring, it is having an override effect. And in many cases, the Supreme Court has confirmed this view that section 238 has got overall, overriding effect on other laws. That means, section 14 of the IBC, if you see, it prohibits, as you see, as you can see under section 14, institution of suits and continuing pending suits or proceeding against the corporate debtor. And all this is to make sure while the RP or liquidator in the process of maximizing the value of the assets, the cases should not be a stumble block. Okay, the proceeding should not be a stumble block. That's the real idea why section 14 and section 33, it's emphasizing on the moratorium they are status quo has to be maintained. Similar provision there in SICA provisions also it was there. Okay, and here it is more specific here, and it's more authoritative in insolvency bankruptcy code than SICA. So insolvency law, if you see, the intention is to see that private entities who are unable to pay debt, to make sure that their companies are reviving by doing a maximization of the corporate assets, value of the corporate assets, and to see that if it's not happening with the earlier management, handing over to the new management, and new management can put their efforts and see that they are bringing up the corporate debtor or reviving the corporate debtor with their efforts, with their capabilities, and need be further inflow, taking further loan or infusing funds. So these are the real idea, motive behind the insolvency code, why the insolvency code brought in, so that by means of bringing the insolvency code, the CRP can be commenced, the resolution plan can be invited, and resolution of stressed assets is addressed by means of approving the resolution plan by the COC initially, then thereafter Honorable Adjudicating Authority. If you see Honorable NCLAT in the matter of Binani Industries, they clarify the objective of the code very clearly. What they said, the objective of the code is resolution. It is the observation of Honorable NCLAT in Binani Industries. Okay, it is objective of the code is first resolution. The second objective is a maximization of value of assets of the corporator. Third objective is promoting entrepreneurship, availability, and the credit and balancing the interest. So nowhere the courts said the objective of the IBC is winding up or liquidation. Though liquidation takes place on failure of CRP, the provision is inculcated, so it is there. That doesn't mean every company has to be taken for liquidation. So it is only that if CRP doesn't work and there is no scope of CRP to work, then and there are many courts have confirmed this view also, that liquidation should be the last resort. Even many orders, Honorable Supreme Court has confirmed that liquidation should be the last resort, and resolution is the sole objective of the insolvency bankruptcy code. See, that's the idea how the revival can happen by means of resolution plan. You must be knowing, you all must be a practicing professional, and as soon as CRP is commenced and IRP became RP, the first duty of the RP is to constitute the COC, IRP, RP to constitute the COC and invite the resolution plan. One resolution plan, what resolution plan? You all must be knowing it's nothing but a plan proposed by the resolution applicant for insolvency resolution of the debtor as a going concern. That's the very important purpose of the resolution plan. Where I was showing one circular where Reserve Bank of India also gave a direction how a resolution plan should be given and how the resolution plan should be considered by the bank. That is totally different from the resolution plan what we are discussing in insolvency bankruptcy code. That's why I said the moment insolvency bankruptcy code has come into effect, it supersedes all the earlier provisions governing the financial failures. That's why I said it is a core. So it cannot be parallelly implemented with other. Okay. If it is brought under the ambit of insolvency code, then it can be implemented. So we need to understand more today the provisions of insolvency code and what are the avenues that are available in the insolvency code. The one of the avenue and one of the recourse available is inviting the resolution plan. And in fact, one important thing that we should note that the resolution plan may include provision for the restructuring of the corporate debtor. We were seeing in the earlier slides restructuring of loan. Okay, but here it talks about restructuring of corporate debtor itself. How restructuring can take place? Restructuring can happen by means of merger or amalgamation or demerger. In fact, that opens the entire opportunity of reviving the corporate debtor. So now a resolution plan itself can be given for restructuring. It's not that a resolution plan is simply acquiring the corporate debtor and acquiring in the same running corporate debtor in the same format. It can be acquired and it can be restructured, and the restructuring can take place by means of merger, amalgamation, and demerger. So that means, so today it is possible that the stressed assets can be acquired under the insolvency bankruptcy code and can be restructured. Okay, and the stressed assets or loan, whatever we call, of course, the loan and assets both should be seen as one and the same under the IBC, because here we are trying to address the stressed loan by selling the stressed assets. So here it is very important to understand resolution plan. What is contemplated by Reserve Bank of India in that directive is totally different. Okay, but here the resolution plan, what is contemplated, subsection 26 of section 5 of Insolvency Bankruptcy Code is totally different. And here it gives a more avenue and it gives more opportunities for the resolution applicant to make sure or to see that the resolution plan is submitted by means of restructuring the corporate debtor by way of merger, amalgamation, or by way of a demerger. So this is a very good initiative that the government has brought. Otherwise, it is very difficult to implement the resolution plan. How it is given, if same is implemented in the same manner, then it will all the more will become difficult because whatever the benefit that corporate debtor, whether transferor or transferee, gets under the amalgamation demerger. Okay, they cannot get the same privileges, benefits in the resolution plan unless mergers amalgamation is permitted in the resolution plan. So resolution plan today can be given. In fact, after introduction of the insolvency bankruptcy code, this restructuring word has been, and the word merger, amalgamation, demerger word has been inserted because the government has felt the importance of it. So immediately they inserted in area. They thought, okay, that resolution plan without giving these options, without giving these avenues, it is very difficult to implement the resolution plan by the resolution applicant unless there is a provision given enabling the resolution applicant to restructure the corporate debtor either by means of merger, amalgamation or demerger. Do you feel any difference between merger, amalgamation and demerger? Do you have any idea about it? What is merger? What is amalgamation? Just suppose we are all the social professional and we must be handling plan, all that. But merger, amalgamation, demerger, I think insolvency code doesn't talk about merger, amalgamation, demerger. So we have to take a reference from only Companies Act 2013. I don't know how many of you, the participants, out of 20 participants now, how many of you would have dealt with, I don't know. But do you feel merger, amalgamation are one and the same or different? Or merger, demerger, all are one and the same or different? Or restructuring of corporate debtor, including by way of demerger, amalgamation, demerger. That means restructuring can be any other thing other than the merger, amalgamation, demerger, because it only says including by way of demerger. That means restructuring can be in any form. What are the way the restructuring can be done? Any idea? Anybody can share your experience on that? You must have handled any resolution plan or even today in liquidation, it is permitted. Inviting the scheme under section 230 is permitted even after passing liquidation order. That provision has been 2B has been reduced. You must be knowing it. Do you have any experience of handling amalgamation, demerger, part of the resolution plan or part of the liquidation order? No idea?
No, sir.
No. Oh God. I think that's a real what to say experience that one should get by handling schemes and mergers and demerger as part of the resolution plan and even part of the liquidation process. See, resolution plan, so that means resolution plan is very open. We can say that many things can be brought in within the framework of resolution plan, within the meaning of the resolution plan. Now it is opened up totally because the moment it says resolution plan may include provisions for restructuring of the corporate debtor, it says including by way of merger. So I was telling this only. Including mean that means any other thing also possible other than the merger. That means we have to directly go to the section 230 of the Companies Act, which talks about complete compromise and arrangement. So even of course, compromise arrangement, the arrangement includes merger, amalgamation, and demerger. I'll explain you in detail later about the merger, amalgamation, and demerger. Let's see the time accordingly. I will explain. But let's now understand how this can be, stress assets can be revived and a solution can be given to the stress assets by means of resolution plan or by means through a liquidation process by inviting a scheme after even not in a liquidation. So today it is possible. So if you see regulation 39, it talks about approval of resolution plan. And but here one important thing that we have to see before before giving a solution to the stressed assets, but as a IRP or as a liquidator, they are duty bound. The professionals are duty bound to make sure that the resolution professionals submit to the committee all resolution plan with comply all requirements of the code and regulations made thereunder, and along with the details of preferential transaction, undervalued transaction, and extraordinary credit transaction and fraudulent transaction. So these are the 4 things that one should keep in mind. That's very important. One should keep in mind, because keeping this transaction, the idea is not that keeping all this transaction open or allowing a corporate debtor or ex-promoters to just sparing the ex-promoter from all this. Revival alone is not the idea of purpose of the insolvency code. The insolvency code gives obligation, duty to the resolution professional to see that insolvency professional that These are the transactions are reported and submitted to the committee, and not only to the committee, and also file an asset application before under budgeting authority under section 43, 45, and 50 and 60. So this is another important responsibility as a resolution professional and insolvency profession we have. So these are the sections that we have to see. That means these are the sections which we need to keep in mind while getting into the process of seeing the opportunity and possibility of giving resolution for the stressed assets, whether any professional transaction is took place, any avoidance of undervalued transaction has took place, or any fraudulent activity, wrongful trading has took place, defrauding the interest of the creditors. Then in which case we need to file an application under 66 to see that seeking a direction of under budgetary authority for seeking direction to order for contributing to the assets by the ex-management who engaged, who involved in the fraudulent activity, wrongful trading in the affairs of the corporate debtor. So these are the stages, petition by creditors, and you must be knowing by now everything is settled almost. The process is settled by now, and that days have gone where in 2017 we were trying to understand about the process, basic process, how it should be filed, and what is the process. Now the process to some extent it's settled now, and application has to be, petition has to be made by creditor, financial creditor under 7, operation creditor under 9, corporate under section 10. Then after that admission should take place. Of course, now 14 days time, there are a lot of orders have come. 14 days time, it may even take more than that. 14 days time by adjudicating authority. But what are the timeline given to the insolvency professional? They have to stick on to the timeline, and the appointment of IRP takes place. Then initial 30 days time, the code gives certain responsibility to the IRP, taking over the management and preparing the list of creditors and call for the resolution plan and restructuring, all that. So these are the things that IRP has to do. Even the resolution applicant is given certain responsibility, and while submitting the resolution plan. And 80, if you see, almost if you see the observation given by IBBA, some time of time they said 80% of the success are resolved via IBC through an IBC route, and only 20% in liquidation. But today the days are changing, and of course much more revival is taking place, and more than revival, recovery is taking place much more, as I was referring. Even with the fear of coming into IBC, the promoter settling the dues. That's the recent development which you have deliberated in the little earlier. Then resolution applicant, who can be a resolution applicant? Who will be treated as a resolution applicant? So a person who is individually or jointly who make an application, or who submits a resolution plan, and to the resolution professional, who invites, pursuant to the invitation made under section 25(2)H on IBC. And here important thing is, after invitation by the IRP, any person who is eligible under IBC should submit. They can submit a resolution plan and become an applicant. So in fact, the resolution plan should be based on the information memoranda provided by IRP. So it is very important that one should see that the plan is prepared based on the information provided by the memorandum. Because information memorandum is the base document, supposed to be a base document for the resolution plan. Now, taking this opportunity, this is one way where IBC insolvency code is giving the avenue or resolution, or giving a way out for resolution applicant, for the corporate, or any person who wanted to venture into revival of any corporate debtor, or wanted to venture into the business which was earlier carried out by the corporate debtor. They can step into the shoes of the earlier ex-promoters, earlier management. Then they can take it forward. the business of the corporate debtor. Once the resolution plan is approved by adjudicating authority. So this is a very important opportunity that a resolution applicant should see that they are grabbing that opportunity. So what is that IBC provides for? It provides acquisition of business comparatively low cost because they are getting at lesser value, and it really promotes entrepreneurship because it changes the hands, the management from one hand to another hand, so that the new management will take a interest and see that they are improving lot the operations of the and development of the company. They contribute the development of the company better than the earlier management. So there are much more benefits are there in IBC comparing to earlier laws. So how, if you see the acquisition of business, what is the resolution applicant? See, resolution applicant, how he become. So importantly, if you see resolution applicant, what are the role, what are the benefit that a resolution applicant get the moment they make an application, what they get. If they submit the resolution plan, all that resolution applicant should see that before they prepare a plan, before they submit the resolution plan, they are going through the information memorandum given by the resolution professional and making sure that the information, whatever given memorandum is taken into consideration while preparing a resolution plan. If a resolution applicant wants to take over the business, then this is a real opportunity given to the resolution applicant under the Insolvency Bankruptcy Code, where by means of giving a plan, he can acquire the business of the company. Business of the company as a going concern, he can. So that's a real advantage that acquiring a business of a corporate debtor as a going concern. Okay. Now again, the resolution applicant get an opportunity to get into the new domain because he may not be having experience, or still he may not he may be having a anxiety to do the business, but he could not pursue for want of more fund or want of opportunity. Okay, but the Insolvency Bankruptcy Code gives really a good avenue, good way out, or give a good opportunity for these kind of investors and resolution applicant, whereby they can invest their money and they can put their effort to make sure that the new domain also they are getting into the new businesses and improve the business operations of the corporate debtor by putting a lesser value. Because if they start the same company, suppose if they have to spend 1,000 crores to start the same, today under IBC they get lesser value because they get the assets and land and building factory assets various basis, and under the order of honorable adjudicating authority, the blessings of the court is there. So they get at a lesser value with the blessing of court. So that's the real advantage where the investor is getting when they come and resorting to the route of insolvency and bankruptcy code, rather going outside, getting into the process of investment outside the ambit of insolvency board, bankruptcy code. If they get into insolvency bankruptcy code, they get a lesser value with the protection. That's more important comparing to other avenues, other laws, other way outs, what are available. So now it really encourage the resolution applicant, and they also it also improves the entrepreneurship in the resolution applicant by giving an opportunity to the resolution applicant to make an application or to submit resolution plan to the resolution professional and to take it forward with the approval of our adjudicating authority. So these are the things, as I was explaining, that they are getting at a lower cost, and they get all the dues or pending outstanding in the company is waived. They get a clean slate. So that's the advantage of acquiring a business assets, stress assets under the code, then acquiring the business or acquiring the assets under any other methodology, any other way, acquiring under the via through IBC, Insolvency Bankruptcy Code, it really gives lot of immunities and privileges to the resolution applicant. But I think by now, many of professionals must have handled this, and even the promoters and entrepreneurs by now, they would acquired lot of companies, and they would understood the real importance and the benefits what they derived out of code. But still, much more we need to explore to see that the stress assets are resolved. What is the process followed? As I was referring, the CRP is initiated, then admission of application, then CRP is commenced, then there are procedural compliances, then resolution plan is given by resolution applicant, the resolution plan by resolution applicant. So what is the how the maximization of value of CD assets is taking place? Because the provision provides for the resolution plan can provide for transfer of sale of assets all or any part. See, this is the real advantage which I was telling you in a plan. So it can provide for transfer or sale of all assets, all part of assets, all or any portion of the asset. And restructuring of CD by of merger among demergers is very important. Same way, substantiating acquisition of shares, merger, consolidation, all is possible. And same way, by cancellation, delisting of shares as a copy data, it can happen. Same way, satisfaction modification of any security interest, they can give a research plan, accommodating all that with the provisions of all this. So issuance of same way securities of the corporate data by for cash or property security. So these are the way where the resolution plan could be given by resolution applicant, and the asset maximization can take place, by means of providing any of this recovery through any of this mode in the form of resolution plan. Of course, today evaluation matrix also is an important tool for successful resolution plan. Of course, today the provisions are inserted in the code, how the evaluation should be done, and what are the methodology has to be followed by, what are the parameters has to be followed, formulas to be applied by RP or committee while considering the resolution plan. All is in place today. So it's not that simply somebody can jump in and they can get the corporate data stress assets. There is a disciplined way how we should plan should be given and how it can happen. In a disciplined way, it should happen. And today the process and provisions are introduced and inserted in the INB code. So based on this, the resolution professional should make sure that he is applying the evaluation matrix and the percentage and weightages, and he analyze, then he bring to the take it to the knowledge of the committee of creditor and brief the committee of creditor and present before the adjudicating authority after approval of the COC. So that means there's a disciplined way how the corporate data has to be revived. It's not that some process they by a process they simply submit a plan and simply it is getting approved. No, in fact, how it has to be evolved, evaluation has to be done. How the evaluation has to be done, and how the process has to be followed for the evaluation of the plan, and how the approval has to be given for any particular plan by the COC, and what are the benefits that can arise out of the resolution plan, and everything today is incorporated. In fact, our IBBS, whenever is required, they rise up to the occasion and see that they are bringing up amendment wherever required. And today the code has provided the complete structure, how the matrix has to be evaluation has to be done, and how the plan has to be approved, how it has to be considered by the committee of creditor, and how many opportunities can be given. And after giving this opportunity, how the plan has to be considered again, and who all can be given an opportunity. And after that, how the plan has to be filed, the adjudicating authority, how the adjudicating authority should be dealt with. See, all this evaluation matrix, how it should be applied with. See, this becomes a complete process. So by which a resolution plan is getting, presented to the COC member, and it is getting approved by the Honorable Adjudicating Authority. So one is the CRP process, the second one is a liquidation process. Even in liquidation, as I was referring, when a company enters into liquidation, how the liquidation takes place when there is no resolution plan during CRP, then liquidation, then naturally it has to come to the liquidation by order of the Honorable Adjudicating Authority. AA reject the resolution plan, then also AA passes an order for liquidation. Same way, 66% he was decided to liquidate the company. Then to liquidation order is passed, and the company corporate debtor get into the liquidation. Now, when the company comes into liquidation, what happened? The resolution professional is becoming a liquidator by means of an order of appointment by AA. So this is very important to understand. Now there are, let's try to understand the recent development in liquidation. Because the days have gone where we understood that liquidation is nothing but liquidator has to see that he is simply collecting the claim and collating the claim and collecting the claim and verifying the claim and admitting the claim and preparing the list and finalizing the creditors and due amount and bringing the e-action for sale of assets and selling the assets and out of realization of the liquidation estate distributes the assets to the whatever the list of stakeholders, creditors prepared by him after admitting the claim. So this is how the normally a liquidator is looked at in earlier. In the earlier scenario, as you know that professionals are authorized today, empowered with this responsibility only after advent of the Insolvency Bankruptcy Code. But before that, if you see under Companies Act 1956, even 2013, only the court, the liquidation process was under the clutches of or under the powers of the court only. You see earlier provisions are now section 270, 271 of the Companies Act 2013, earlier 433 Companies Act 1956 was dealing with the winding up. Okay, so it was totally on a different level where it was completely under the guise of and blessings of the Honorable High Court, and Honorable High Court appoint a liquidator, and the liquidation takes place under complete guidance and supervision of the Honorable High Court. In fact, the liquidator office as deemed considers as part of the High Court. So that was the real benefit earlier a liquidator was having, because he was attached to the Honorable High Court while executing, delivering the responsibility of a liquidator. But today the officer though considered as a court officer, but they are not attached to the any court. But of course today the insolvency professional who is acting as RP and liquidator court officers, and they are the officers of the honorable tribunals and executing the job. Today they are attached to the tribunal, but earlier the liquidator was part of the government. So that's what the difference between the earlier regime and today's situation of the liquidator. So if you see Honorable Supreme Court in the matter of substitution, so they made it very clear while they are before passing an order, what they observed is very important in this. So they observed what is interesting to note, that the preamble does not in any manner. I think you have to see the preamble. One has to read the preamble before going into any act, because preamble only capture the real purpose why this particular act is enacted. If you go and read the Money Laundering Act, you can see the preamble clearly says what is the purpose of the act. If you go to the Companies Act 2013, says clearly what is the object of the act. So like every act, every code has got object. The preamble will spell out clearly what is the object of this particular code. In that way, if you see Insolvency Bankruptcy Code, it clearly says that purpose of the code is revival, not liquidation. That's why the Honorable Supreme Court said that the preamble does not in any manner refer to the liquidation, which is only available as a last resort if there's either no resolution plan or the resolution plan submitted are not up to the mark. So what exactly will match? It is not matching the, coming up to the mark. Even liquidation, liquidators will sell the business of corporate as a going concern. This is the first impetus that is given by the court, that during the liquidation also the liquidator can sell the business of corporator as a going concern. Taking a lead from this, then subsequently the Honorable NCLAT in the matter of C. Segaran Amit Gupta directed that they gave a direction to the liquidator that we direct liquidator to proceed in accordance with the law. We have to verify the claim and take control of all assets and do whatever has to be done under the provisions of insolvency code. And before taking into sell the assets of the corporate debtor, the liquidator will take steps in terms of section 230 of the company. This is a very important thing one has to understand. That only I was referring that the entire code does not talks about any scheme of merger, demerger, or scheme of amalgamation. Even scheme of restructuring doesn't talk. So, but it enables today the insolvency bankruptcy code enables, but does not say how it should be dealt with or what is the process to be followed. Does not say that. So here that means then the court very clearly said that all this the revival process, whether by merger, demerger, or amalgamation, but they have to take steps. The liquidator has to take steps in terms of section 230 of the Company Act 2000. This is very important. 230 is a very wide section and which covers the entire gamut of entire restructuring process. The complete compromise and restructuring entire process covered in section 230. That means today's resolution plan, not only as part of resolution plan, the entire restructuring can be done. So that means today we have got a resolution mechanism enlarged. The resolution mechanism is wide. That's what we need to understand today. The resolution mechanism today is wide. It's not that simply only during the CRP process by means of resolution plan, the stress assets can be, can be bought or can be acquired. No, it's not like that. As a going concern, more particularly. Even in liquidation also, the stress assets can be acquired as a going concern. The business can be acquired as a going concern. Regulation 32 of the IBC liquidation regulation 2016 makes it clear. Section 32 A to E makes it clear what are the ways that the assets of the corporate data can be sold, whether piecemeal or consolidated or as a parcel, as a going concern, business a going concern, corporate data as a going concern. So every method has been incorporated and the process has been incorporated in the regulation of liquidation regulation. So now if you see the Honorable NCLAT has made it clear. In the matter of AC Segaran versus Amit Gupta, they made it very clear that these are the processes to be followed. And now liquidator, but one more rider is given in that. So the adjudicating authority, if so required, it will pass an order. Only on failure of revival, adjudicating authority and the liquidator will first proceed with the sale of corporate debtor, wholly thereafter, if not possible, to sell the assets in part in accordance with the law. So that means the liquidator, if initiates, he will complete the process under section 230 within 90 days. This is the cap given under the order of the Honorable NCLAT. This is the cap within 90 days. The process, the scheme process has to be completed. So taking cue from this, the next judgment has come by given by Honorable NCLAT, the matter of Shivaram Prasad versus Dhanapal, who is none other is me, my own matter, where they given a direction stating that the liquidator is required to act in terms of section 230, and if you see, it furthermore enlarges and widen the scope of dealing with the stress assets corporate debtor under the IBC it much more gives a widened scope, broad scope to deal with the assets of the corporate debtor, stress assets, of the corporate debtor. So the order provided that if the member or corporate debtor or creditor, like FC or OC, approach the company through the liquidator for compromise by making proposal payment of all the creditor. The liquidator on behalf of the company will move an application 230 before AA in terms of the observation made above, because the order provides for detailed orders is given and it provided out after the detailed order, it concluded in this manner. And on failure as above, steps should be taken for outright sale of corporators so as to enable employee. So this is the order passed by Honorable Included in the matter of Shriram versus Dhanapal. So that means by order, the Honorable Included and courts have enlarged the scope of selling the corporate debtor or the assets of the corporate debtor, business of the corporate debtor. So that now it is almost many orders have been passed. Now, say ordering for sale of corporate debtor as a going concern to the buyer. After this now got evolved and developed, the IBC got developed much more, much better, whereby the corporate data stress of the corporate data and corporate data itself sold as a going concern, business corporate data sold as a going concern. So all today is possible by virtue of this order and subsequent amendment in the regulation by IBPA. So now if you see another case which Honorable Supreme Court has held in Mehal Homes, whereby it says it also does not appear to be necessary to restrict the scope of provision concerning the purpose which it is enacted, namely revival of the company. Okay, it's rather dissolving the company, it is allowed. Moreover, section 391 1B gives right to liquidator in case the company which is being owned up to propose a compromise or arrangement. So this only given a clue, to take bring the process of scheme, compromise and arrangement during liquidation process of the under the IBC code. So this is the enabling section 391 1B, taking quoting this provision only. Honorable Supreme Court also said that which is possible under 391 1B under Companies Act also should be made possible, should be taken, credence has to be given, okay, drawn to the provisions of 391 when the stress assets is dealt with under the code. Okay, therefore, if you see, the liquidator is given rights under the Companies Act. So now the court has felt, Honorable Supreme Court and inclined, and today it is settled that the liquidator is given authority that I can sell the assets in a manner as prescribed under the code by means of liquidation regulation. However, the regulation provides the liquidator is empowered to deal with the stress assets of the company, and it can make sale the assets and see that the solution is a resolution is provided to the assets during the liquidation. So this is a real impact today. What to say? Real benefit today. The resolution applicant or a buyer in the insolvency process, means in the liquidation process while buying the corporate debtor, assets of the corporate debtor, business of the corporate debtor as a going concern in a piecemeal basis also. So this is a real advantage today we got. So after these orders, IBC went on to amend the provisions of and insert regulation 2B, wherein the provision 2B talks about where a compromise amendment is proposed in section 230 shall be completed within 90 days. Time taken shall not exceed 90 days. That 90 days shall not be included in the liquidation period. Any cost incurred by liquidation shall be absorbed. So giving much more clarity and bringing recognition in the insolvency code through regulation. The IBPA brought inserted 2B, whereby the compromise and arrangement also brought within the scope of the. Before this amendment, the compromise arrangement was not part of the insolvency bankruptcy code, but wherever in the resolution plan it was amended to include, part of the resolution plan, compromise and arrangement by means of scheme and amalgamation, whereas the liquidation was not there. But after the introduction of a class 2B, the compromise and arrangement also was inserted during liquidation. It is possible. So now, what are the options the liquidator shall have while dealing with the stressed assets under the liquidation? These are the way which I explained to you. Sell the assets on the standalone basis, and slum sale basis, and sell assets collectively, and sell assets in parcel, and corporate data itself as a going concern, and assets of the corporate data as a going concern, business of the corporate data as a going concern. I told you as per regulation 32E, sell the assets corporate data as a going concern. So regulation 32 provides all these methods, how the assets should be dealt with or should be sold by the liquidator during the liquidation process. So as you all know that the liquidator has to follow the method of giving the e-action, and he has to prepare a market strategy through marketing, involving market professionals, and also an advertisement, by clearly spelling out by means of e-action information memorandum. He has to spell out clearly the terms and conditions of the same, and reserve price, and what is the EMD, and as well as what is the pre-bid qualification, if any. And reserve price shall be the value of assets arrived at in accordance with the regulation 34. Such valuation shall not be more than 6 months old, and all this is become part of the regulation today. And same way, it enables the private sales also for selling the assets through private sale with approval of honorable executing authority. Same way, private sale may be conducted. Now, lots of developments are taking place in this. Private sale may be conducted through directly liaising with the potential buyer and agent, and through retail shop, and through other means, and maximizing the sale of assets. And the respective regulations has been inserted by IBC, how the e-action should be dealt with by the liquidator. Same way, how the private sale can take place. By following the process as provided in the code, in the IBB regulation 2016 by liquidator. So very importantly, 32A provides as a sale as a going concern, where a COC has recommended sale under class E or F of 32, regulation 32, or where liquidator has an opinion that the sale under class E or F under 32 shall maximize the value of corporate data. It shall endeavor first to sell the corporate data, no assets of corporate data under said classes. This is the new provision and being inserted, the regulation inserted 32A, sale as a going concern. For the purpose of sale under regulation 1, the group of assets and liabilities of the corporate data as identified by COC under regulation 2 of regulation 39C of the IBBA insolvency resolution process of corporate data shall be sold as a going concern. This is very important manner, method, how the assets can be sold. How the assets can be sold, that's another very important method has been provided by the regulation, whereby the COC has to identify the group of assets and advise the liquidator and how it should be sold after order of liquidation. So before order of liquidation, in the COC meeting, which is considering the corporate data for liquidation, the COC member has to see that they are identifying and giving the group of assets which should be sold as a part of the liquidation sale by the liquidator after liquidation order is given by the honorable adjudicating authority. So this is very important provision that one should understand. So here, if COC is not identified, has not identified the assets, regulation 39C. Now, if you see, the liquidator shall identify the group of assets to be sold as a going concern in consultation with the consultation committee. So this is another important thing that the liquidator today has to do. So another amendment has came wherein liquidator is also given an responsibility to see that if case COT has not identified, liquidator will identify and group assets in consultation with the consultation committee. Now again, in subsection 4, if you see, if the liquidator is unable to sell the corporate tax business on the class C and F within 90 days from now, they shall proceed to sell the assets under piecemeal and parcel out here our outright sale, which where I showed you. These are the methods where now in case the liquidator is not able to identify asset, then he has to follow any this method to sell the assets. Now coming to the assessment of sale as a going concern, because this is the real way out or method whereby the stress assets can be addressed. Because the who are buying the assets, if they are buying a factory, a land and building and plant and machinery, if they buy not as a going concern, then there is no use. It is then it has to be sold only, resold only again. There's no use of buying it. Then the purpose is defeated. Okay, buying in a plant and machinery, it will be like a trading. So if the business people, when the business person will really get benefited, only when the business person acquires the asset as a going concern. Therefore, the same factory can be run, same plant and machinery can be run. Whatever the approvals, with the same approvals, they will have an opportunity to run the factory. Say that so that they need not to go stand in every department for approval to run a factory, or they need not to start from the scratch to establish a factory, because even to establish a factory it takes a year, more than a year, and we need to have a lot of process to establish a factory. We need to involve a lot of professionals and need to buy the machinery, proper machinery, identify where to buy and what are the machineries to buy to assemble and bring a factory into use. So it involves enormous effort and money and time. So all that happening in a shortcut method, in a quick method, is by buying a land and building, buying a factory or stress assets of the corporate debtor under the insolvency process, under the insolvency and bankruptcy code, either during the resolution plan, by means of submitting a resolution plan, or by means of submitting a scheme, or even by means of submitting a bid to acquire the assets of corporate debtor as a going concern, or corporate debtor itself as a going concern. So all these methods now evolved in the insolvency bankruptcy code. Now all the more, now lots of avenues come. It is opened up now. So now acquiring the corporate debtor under the insolvency bankruptcy code, stress assets is much more liberalized. Not like days when code got introduced, where we were not having this option. That time we were not having all these options. So code got slowly evolved. Through by way of an amendment, by way of an order of honorable courts. Now that lots of avenues have come, lots of modes and methods and wayouts have come, wherein how the assets can be acquired, and investors given lot of opportunity to acquire the assets of the assets or corporate data itself as a going concern. I think that's a good opportunity for the investor to make sure they are acquiring. Otherwise, they have to spend enormous time to incorporate a company, to install a factory, to install a machinery, and to build up a factory, to buy a land and building, and to take an approval to build a factory and buy a plant and machinery, assemble it, and bring everything together. It takes years together and with lot of efforts. All that's happened in a ready-made, in a quick manner under the, that's a real advantage and opportunity as an investor can get. I don't think investor can get when they directly venture into farming into the company or factory and getting into the business. Then they have to spend at least three to 4 years at least to settle to commence the operation. But here they can directly commence operation after refurbishing and redoing the important refurbishment and the important replacement of machineries. They can do and start the process without waiting for any other things and all. Okay. Now new establishment of a factory or incorporating corporate data, then it takes a lot more time. So comparatively, IBC give real benefit, way avenues and way-outs to the resolution applicants and new investors to acquire the trust assets or corporate debtors. So now, as we see now, regulation also has been introduced under the code, whereby today the sale can happen or acquisition can happen, either corporate data as a whole, assets of the corporate data as a whole, or business of the corporate data, or piecemeal basis also. In any method, it is possible now. So now, if you see these regulations are introduced recently, sometime back, so that earlier this regulation was not there. So now it enables and gives responsibility to the resolution professional and liquidator how the assets should be sold as a going concern, and what are the methods should be passed, and what are the process should be followed before venturing into sale of assets of the corporate data as a going concern. Now, if you quickly see the what are the matters, what are the cases dealt with in these matters, and what are the assets that are being sold or acquired. And these are the cases where structure has been acquired. In PSL group recently, liquidated as a going concern some time back. Manufacturing of pipes, they were doing all manufacturing pipes, where when the company came into the CRP process, it was not receiving any resolution plan. So committee of creditor decided to liquidate. So it was bought as a going concern in the liquidation process. So whether the sale of a company as a going concern under liquidation different from resolution plan under CRP, the question, is there any difference? In fact, we need to discuss much more, to understand how if the corporate data or assets of corporate data acquired through a resolution plan, or if a corporate data or assets of corporate data acquired in the resolution, liquidation process. So of course, the amendments have come under CRP also, and I think corresponding amendment is yet to come under liquidation, giving privileges and protection immunities when the company is acquired during the liquidation process, which is there under CRP regulation, which is not there under the which is there for the during CRP. The immunity which is provided during the CRP, similar immunity has to be provided to the buyer in the liquidation process under the during the liquidation stage. Probably in a recent time, but we can expect soon. The government court will understand that whatever the immunity that is provided during CRP, same immunity should have. Though courts are coming out taking references from CRP immunities, but still there is no explicitly it has not spelled out how it is spelled out in the CRP. So we have to wait and see. Probably we may get soon those protection in the liquidation process also. So under the resolution plan, as I was referring, which I was explained, the COC can group. They can group and give a responsibility to the liquidator to sell the assets. If the COC is not doing it, a liquidator on his own by following the process, he can group the assets and sell. So this is the time frame which I told you. The time frame for selling the corporate debtor or assets of a corporate debtor, completion of the liquidation as a going concern. Everything is clearly spelled out today in the form of regulation. It makes it very clear. And even if nothing works out, the now assignment also has been introduced in the regulation. So assignment of not readily realizable assets can be given in the form of assignment, may be assigned or transferred under regulation. After consultation with the stakeholder committee and regulation formed resolution 31. What is not available asset is nothing but assets included in the liquidation asset, which could not be sold to available asset, and include contingent or disputed assets which could not be sold, can be assigned, though it can't be sold immediately, but it can be assigned. The liquidator can assign the assets. Okay, that's very important. Another avenue how the stress assets can be dealt with. Now, as I was referring IBC and the earlier even earlier closure of liquidation process when there is no assets. There are assets, we can't do earlier closure only after releasing the liquidation estate, distributing the profits to the stakeholder. After completing the process of the liquidation, then only it is possible. Then only liquidator can venture into closing down the liquidation process or filing an application for dissolution of the corporate debtor. Before that, the liquidator is not empowered to do. These are the matters where the Supreme Court and Honorable Supreme Court and Honorable Inclats have passed in so many matters where corporate debtors can be sold as a going concern. Because these are the recent developments. It was not originally there in the insolvency bankruptcy court. These are the developments that took place by means of an order and by means of subsequent amendment in the insolvency bankruptcy code. And also there are lot of judgments are there. That's why I put listed out all these. These are all these orders and judgment really throws lots of modes and methods and situations how a corporate debtor is acquired during CRP, how the corporate debtor is acquired during the liquidation process as a going concern, or assets of the corporate debtor has been acquired as a going concern, how the matters has been dealt with out seen by Honorable Adjudicating Authority and Honorable Unclad and Supreme Court, how they dealt with, how the benefits is given to the buyer of the in the liquidation process and association applicant the CRP. All these orders will help. You can leisurely go through orders and it will take a lot of time if we have to cover. We need a separate section to cover these orders. Okay. So this is the presentation which I thought I can deliberate with you. So any doubts you can discuss with me. So today I'm there to discuss few points on this. I deliberated. So probably much more to understand, no doubt. We have much more to understand, but still law is evolving. We have to wait and see. In the times to come, the law much more may evolve. Okay, we have to wait and see. But today, what are the avenues are available, which I explained to you. Probably we have to wait and see what are the avenues that may come in future. But any questions or any points to deliberate, you can ask me. I will take it up, then we can conclude.
Hello.
Yeah, tell me.
Sir, I wanted to understand your perspective about IBC
Hmm.
because in the today's scenario we are meeting bankers, we are having discussions because as a IP I am handling IBC cases. But many times it happens like the bank officials, they are little skeptical about IBC and they talk about surfacing more. But as we all are aware, IBC is a very beautiful law. And in IBC we talk about resolution and not of recovery.
Okay.
But what is your perspective about IBC? Because as I said, the bankers are very skeptical for giving business in IBC.
See, actually, this is the reason now. I think you recently you would have come across government was suggesting, okay, that to come out with the what to say, I won't say code of conduct. They wanted to come out with some guidelines for committee of creditors, because there is no guideline. There is a guideline governing operations or role and responsibility of the insolvency professionals. There is a guideline and rules in place how the company should be run. Okay, and there are guidelines in place for other matters. But with respect to the COC and bankers, okay, there is no guideline. Of course, earlier the IBBA was trying to bring out some guideline. Then RBI was objecting to that. Then probably after that, I think IBBA left it because RBI was objecting to that. Now again, that scenario is emerging again. Now again, I have come across few information whereby the government is proposing to come out with the guidelines to the COC members, how they have to deal with the corporate debtor and how they have to represent and how they have to conduct themselves in the CRP and liquidation process. In fact, that guideline is really required. There's no doubt at all. I second your view where they are very skeptical only in the insolvency bankruptcy code. There's no doubt at all. Their more mind is going on seeing the color of money. Okay, we are talking revival, no doubt. IBC code, you see last 2.5, 3 hours discussion, the government, the orders passed by the honorable courts and the amendment brought in by the government, all are towards revival. But we could not really see that level with the banking.
Right.
Banker. We could not see that level really with the banker. Their approach more towards seeing the color of money and
Yes.
recovery. Yeah. I
Right.
can't deny. Can't deny.
Right. Right.
Thank you, sir.
Any other question or any other points? Madam, if there is no question, can we conclude, ma'am?
Sure, sir, we can conclude.
Yes.
Thank you very much, sir, for taking out time and addressing session on the topic resolution and way out of stress under IBC. Thank you very much for sharing your experience and your learnings on the topic and making the session interactive and insightful. Sir, you are requested to please share your presentation.
Sure, ma'am. I'll share. Thanks a lot. Thanks a lot for each and everyone for your patient hearing. See you again. Thank you.
Thank you very much, sir. Now the next session will start at 1:30. Sir, shall we start?
Good afternoon, ma'am. Yeah, and that.
Good afternoon, everyone. Now our second session will be taken by Mr. Jigar Bhatt, sir. Jigar Bhatt, sir, is a member of ICAI. He is insolvency professional and he has also done certification in forensic audit. He has professional experience of above 15 years in banking sector. His area of expertise includes CIRP, liquidation under IBC framework, valuation of securities and financial assets, risk-based internal audit, transaction audit, credit risk assessment, stress asset resolution, and debt restructuring, business turnaround strategies, portfolio due diligence, preparation of resolution plan, etc. Now I would request sir to proceed.
Thank you so much for such a wonderful introduction. And yeah, very good afternoon to all the participants. And I believe all are members of ICSI Institute of Insolvency Professionals. So very warm good afternoon to all. And so I think this is a post-lunch session. So I will definitely try to keep it as interesting as possible. Overall, the subject which has been given is with respect to resolution and way out of the stress asset under IBC. I've been told that I need to discuss on the regulatory framework and management for resolution of stress assets under IBC, wherein several RBI circulars, SEBI regulations, and other such legal provisions will come into picture. But I'll keep theoretical aspects and the legal circulars at minimal discussion because all are members of ICSI Insolvency Professionals. So we all have cleared examinations. I am sure that we all are expert in legal understanding and reading of the circular. So I will try to share my knowledge which I have gathered during last 5-6 years of practice into the IBC. And I have been an advisor to a couple of ARCs as well. So I have seen a lot of acquisitions by an ARC, portfolio due diligence, then resolution. So I will try my best to share whatever experience and learning I have gathered in last 4 or 5 years under the IBC regime. So if whenever participants have any query, you can either put it in a chat box or you can pause me. So at appropriate time, I will take up the queries. Right? Shall we proceed? So this is the broader agendas that we would be discussing so that I should not go beyond my allotted subject. So that is the reason I have prepared this agenda item, which we usually do for the whenever we conduct any COC or SCC meeting, so that a discussion remain quite objective and we can arrive at some good decision making. So here also I have tried to put discussion item as an agenda item, and I will definitely try to cover all the agenda items as given to me. And absolutely last 15-20 minutes, we will keep it open for any generic discussion with respect to CIRP liquidation or anything revolving the same. I hope I am audible to everyone because I think participants'
Yes,
mic
sir,
is
you
off.
are audible.
Yeah, thank you, ma'am. Thank you so much. So this is the program outline that has been given to me, wherein I am supposed to discuss and share thoughts on discussion on prudential framework of resolution of stress assets, role of an NARCL in the CIRP. So it is basically a National Asset Reconstruction Company Limited, a bad bank, which we usually call it. Then I have got stress asset in global scenario, and discussion on regulatory framework for special situation funds with respect to IBC. So SSFs are basically part of AIF. So I'll briefly discuss the framework because it is quite legal framework and compliance framework. So as a professional, basically we don't need to go into the details, but yes, from IBC perspective and as an insolvency professional, how beneficial it is to understand special situation funds, I will definitely discuss. Then I got what are the expectation of an investor, resolution applicant from the IBC, that we will discuss. Case laws, if time permits, we'll discuss, and then Q&A. So in order to understand the stress asset resolution framework, we need to see the overview of the stress assets management available with the banking industry as a whole. So as you know, why there is an NPA. So ultimately, it's bank's business to fund. They have to take a credit risk, right? So sometimes a decision may go wrong. While doing credit underwriting, you might have envisaged that industry will perform like this and that, and this would be the impact. Several other external factors are there which were actually predicted at the time of credit underwriting. But situation may change. There would be a global situation as we had seen in 2020. There was a COVID outcome which impacted a lot of businesses and all. So that is the reason whenever there is a business, for earning, you have to take a risk, and if there is a risk, then your decision making may also go wrong. So, see, the most important facet of any robust financial system is resolution of stress assets, because it's bank's business to gather the fund through the current account, saving account, fixed deposit, and other revenues, and ultimately to deploy it in the profitable ventures of a businessman. So basically, they participate in a growth of a business. You would say the business model is like that bank charge fixed rate of interest. So bank's earning potential is limited. So whatever business earns, they have to give certain portion as an interest to the financial institution. Say for example, as a bank, I have lent at a 10%, and if business is able to generate a return at 20%, so they will give me 10%, and balance 10%, they will put it for a further expansion, or ultimately it would be the equity shareholders' money. So they have got an unlimited upper side. So whatever business they can generate for their company, their obligation toward bank is fixed. So interest rate is fixed or variable interest rate, but the portion of the interest would be fixed. So equity holders are having unlimited earning opportunities by investing into the company. When things turn negative, of course, they will say we have got a limited liability and our liability won't be in access to the share capital we have subscribed to. Whereas bank would stand the biggest loser, because their entire principal outstanding may go for a toss if they don't have effective monitoring systems in place, and if they don't have effective recovery mechanisms in place. So to say overview, because of increased NPA, entire banking system goes for a toss. And see, as a borrower, whenever I am borrowing funds, it is my liability. Similarly, for the banker, it is an asset. So if borrower is unable to pay, my assets are getting deteriorated, and ultimately, because my assets are getting deteriorated, I won't be able to pay my creditors, who are basically a fixed deposit holders and a current account savings account holders. So that is the reason for any bank, any financial institution, an effective NPA management process has to be there, and that is the reason RBI has given a detailed guidance with respect to capital provisioning and the risk provisioning, etc. So adequate capital provisioning and risk provisioning is essential in order for bank to sustain any situation which they have not envisaged. So impact of NPA on bank in India, I think as an insolvency professional, we all must be aware. For that, there is an RBI guidelines for NPA classification. There are guidelines on post-sanction credit monitoring and early warning signals. Bankers are also taught in detail the cases in credit fraud, so that whenever they do any underwriting, they have to see that what kind of fraud that has happened, so that they should try to avoid such kind of exposures. Then there is a guidance with respect to willful defaulters and taking suitable actions, red flagging of accounts. So RBI has empowered bank, whenever there is any account which is a fraudulent account and the promoters are the willful defaulter, then they can trigger actions and red flag those accounts. So banks are having actually very wide power with respect to that. In case of failure, there is a recovery strategy through SARFAESI actions. So SARFAESI 2002 Act basically gives banks to recover and take the possession of the property without going to the court, and they can sell the assets on as is, where is, whatever it is basis, and they can recover their use. Then there is a mechanism, it is recovery through DRT, that recovery tribunals, compromise schemes, and the ARC, which is asset reconstruction company, which we will be discussing in detail. Then there are certain guidelines with respect to restructuring of the trust assets and the pre-pack which has been introduced under IBC, that is actually restructuring or a one-time settlement scheme which is governed through NCLT, though it is still not very much acceptable at economy level, but as we all know, IBC is a growing legislation, and so it will take some time, but pre-pack is actually a very effective mechanism for identifying early warning signals and taking appropriate actions. And then we have got the resolution through insolvency and bankruptcy code. So these are the impactful legislations which are prevailing in India. So Code of Civil Procedure is of 1908, Companies Act 1956, Income Tax Act 1961, Code of Criminal Procedures is 1973. So you can see these are quite matured and legacy legislation. Whereas if you compare Insolvency Bankruptcy Code is a baby, it is just 2016 enactment to use in 2017. And technically speaking, it is operational full-fledgedly since 2018. So it's hardly been 5 to 6 years. So it will eventually grow, and the kind of focus government is having whenever there are any issues which government sees, or whenever there is any representations goes, they immediately take the action and they try to amend and bring the new amendment into the code, so that ease of business would be there and ease of effective resolution through IBC would be there. The first object of the IBC is resolution, that everyone of us know. This is a way. It is basically a tool through which you can find a way to save a business as a going concern. It would be through either restructuring, change of ownerships, mergers, acquisitions, amalgamations, or any other method. So different kind of structure you can create whenever you as a resolution applicant are interested in resolving any entity which is undergoing CIRP or even liquidation. So historically, what has happened under surface, the banks take the charge of the assets and they sell the asset through auction. So ultimately, whenever any core asset, so if there is a consortium lending or there are multiple bankers, and if I as a banker is having exclusive charge on certain properties, in case of default, I will try that my interest should be safeguarded and my money should be recovered. So obviously, banking is also a business. So in order to safeguard your business, you will take the best possible action. In turn, what happens if I am having charge on some critical assets, which is actually a profit generating unit, and without that asset, it is not possible to run a manufacturing facility or a business. And if I exercise my security right over those assets, and if I sell those assets, then ultimately all ancillary assets would be weakened and it would be deteriorated in value like anything. So this was the problem which system was facing, that all banks were trying to realize their own security interest. They were not coming on a single platform to discuss that how to revive these companies. So that was the reason. Under surface, though recovery is there, but ultimately a business, it is very difficult to save a business as a going concern. See, under surface, the provisions are there wherein a bank can even take a control of the corporate debtor, but usually that never happens. Bankers are always focusing, because as a banker, they are expert with respect to the lending business or doing other activities, banking activities. So banks are not in a business of acquiring a unit and running those units, right? So that is the reason whenever there is any default, bank would acquire the asset under surface and then they sell it. So whenever any core assets are sold by banks, the other asset would be of limited use, and that is the reason the value gets deteriorated. So IBC was ultimately enacted to address this kind of issues, because prior to IBC, there was a multi legal infrastructures and systems were available. Like we had a SICA, we had a BIFER. Then there was a Recovery of Debt due to Banks and Financial Institution Act 2000. 1993. Then there was a Sarfezi 2002. So different legislations were there, different acts were there, and all had pros and cons. Obviously, there were benefits, but within the legal system, there is a underlying theme line that a natural justice should prevail and no innocent person should be penalized. So that is the reason all cases have to pass through that system, and that is the reason it takes longer period of time to recover. So IBC came in, and the most important thing which IBC had into the legislation is the time bound resolution, and so that was the most impactful thing which IBC has brought, because it is having override effect over several other legislations. It is having provision of moratorium, so that a dedicated period of 180 days is given, so that a company is not required to deal with any other issues, and a resolution professional who is basically an expert into the resolution field, he can focus, he can work along with all the bankers. Earlier bankers were not coming on the same platform, so under COC framework they have to come on the same platform. So COC, it's kind of a public kind of an committee, because they are supposed to safeguard the interest of all the stakeholders. So if it's a public limited company, they are supposed to take care of the interest of all equity holders who are a public at large. So ultimately, it's a public kind of an institution with a lot of powers, and along with power, they do have a lot of responsibility as well. So under IBC, now all bankers have to sit, and because they are giving decision making, and an independent person is acting as an administrator, so IBC has given a good platform for bringing out the resolutions. And the theme is basically a resolution and not a liquidation. So liquidation is considered as last resort, though it doesn't mean that there should not be liquidation. See, sometimes there could be business which are not viable at all. So then there is no point in trying to revive those business. If say for example, very traditional example, if I say I'm into manufacturing of pagers and my system was like that I won't be able to manufacture mobile phones, then there is no point in someone coming and reviving those business. It has to die. So whenever there is a situation, as an RP, you should advise that, see, it is not a revivable business and the liquidation should be the best possible action, because the earlier you go into liquidation, the earlier you try to unlock the whatever assets which are kind of a generic asset which can be put to use for some other purpose, those assets should be sold. So the earlier you take such decision, you will be able to realize a better value out of the same. So after enactment of the IBC, the Reserve Bank of India specifically directed, and they withdrew several other mechanisms which were in place prior to IBC for resolution of the stress assets. So here I have tried to summarize those schemes which are prevalent prior to the enactment of the IBC. So these are revitalizing of distressed assets, corporate debt restructuring schemes, flexible structuring of existing long-term project loans, strategic debt restructuring schemes, SDRs, change in ownership outside SDR, S4A, so it is scheme for sustainable structuring of stress assets. So these all schemes should withdraw with immediate effect with introduction of the resolution of stress assets revised framework by the Reserve Bank of India in 2018. So whosoever are a bit senior in the profession, they must have worked with the bank and bringing the restructuring through these schemes. The people who are into some different profession like company secretary, advocate, chartered accountant, and coming into this profession after enactment of the IBC, they may not have worked under these schemes. But yes, these schemes had given a good results. But as we said, there is always a flip side of the coin. So whenever any account was getting restructured under these schemes, bankers used to take it long. Obviously, all bankers were not coming on the same platform, and they were some bankers were actually taking advantage by not finalizing the scheme. They were getting advantage of not putting provisions with respect to the NPA. So many a time, whenever some reporting dates were approaching, like 31st March or half-yearly returns, the decision making was actually delayed, and delayed decision making ultimately resulted into deterioration in the value of the company's assets. So yes, after introduction of the IBC, these schemes were withdrawn. And as I said, IBC is a comprehensive legal framework. It's a consolidation of the law. So different laws get consolidated and a code was enacted. The purpose was for timely resolution and the maximization of the value of the company's assets. And IBC has indeed improved structure, different structures are available. So as we know, under regulation 37, a different combination you can work out for bringing a resolution plan. It's a time-bound process. The most advantage is the time-bound process. I have some data in place. Obviously, though upper limit is 330 days, difficult to get the resolution within 330 days. But now, since the law has got matured, there are a lot of precedents in place. So if you pursue the matter wholeheartedly, there is definitely a practical possibility of resolving the corporate debtor within 330 days. And from my practical experiences, I can say around 40% matters which I have worked, we have got the resolution plan approved within a year's time. It's a unified framework for the resolution of the corporate entities, and it replaces several outdated laws and creates a single window for all IBC related matters. So I usually put this picture in all my talks. So this is the corporate debtor, which is undergoing some stress situation, not functioning properly. And this is what we all are supposed to do. So the committee of creditor are actually providing a platform. They are basically a board of directors who would be directing the CEO, that is insolvency professionals. So IP is having certain powers and he is an expert, so he will proceed with the entire process, but there are certain decision making which impacts overall commercial of the company. So a lot of decision making is rest with the committee of creditors, and many resolutions required more than 66% weight of voting. And yeah, this is the company, and this is the ultimate objective. So here we will discuss that which all options are available for achieving this objective, a successful resolution of the corporate debtor. So prior to IBC, I have got some historical data. Thanks to there is one book. It's called Bad Money. It's all about NPA mess by Vivek Paul, who has been a regular writer with Economic Times and other financial newspapers. So whosoever is actually wanted to be there deeply into the resolution profession, they all should read this book because it gives entire history with respect to the Indian banking system and how NPA mass is created and how the history has evolved. Anyways, I am not promoting this book, but because I find it very appropriate, so I thought let me put the picture of this book here. So as you can see, over the period of time, the total bad loan has increased like anything. So 12-13, the bad loan amount was, let me just start the pointer. It was this, these figures are rupees in crore. So 1,93,200 crore was the total chunk of the bad loan in 12-13, and the recovery was 23,300 crores or 12.1%. See, as we progresses, the bad loan has been increasing, and by 17-18, the bad loan has increased 10,36,187 lakh crore. Here, recovery is 40,352, 3.9%. So out of 100 rupees of bad loan, the recovery is only 3.9%. And during this period, the IBC was enacted, and those dirty dozens were put to the IBC process through an RBI circular. And you can see the result. Of course, a large corporate resolutions was one of the contributor with respect to this recovery, which was SR. But you can see that the recovery rate has increased from 3.9% to 13.5%. So yes, IBC has been an effective tool. Many a times, typically, a banker would say that recovery rate is very low under IBC regime. But you should compare. I always tell the bankers, and even the forum wherein the things are getting reported that IBC is having say 25% recovery rate or 30% recovery rate. Other professionals who are not into this field, they always say that IBC is not an effective mechanism. But the recovery rate which has been getting reported is with respect to the claim ratio. Now, everyone knows that whenever there are legacy matters, whenever there are old NPAs, bankers charge a huge interest penalty on those accounts. So whenever you get a claim, you will see the principal outstanding is X, whereas the interest penalty is 2X. So after resolution, if you compare the recovery vis-a-vis the claim amount, you will find, okay, this is a lesser recovery. But if you have to compare with principal outstanding, because when your account got NPA, you had certain mechanism in place for recovery. So you should compare that what were alternative mechanism available other than IBC and what was the success rate. So because those, if I had a in 2017 my account got NPA, I would have exercised under SurfaceZine. I would have tried to sell as best as possible. So whatever assets which are having a clear right with respect to the security interest, I would have sold. Ultimately, the things which I was unable to sold, I am trying that I am getting recovered from the IBC. So you need to compare what was the alternative remedy available other than IBC and what was the success rate. So I personally believe, see, that IBC is actually giving a good results. This is an IBC report card which I have prepared from the financial stability report issued by Reserve Bank of India in June 23. So in couple of months time, we would be getting a fresh financial stability report. But this is giving a good perspective that total matters admitted to CIRP are 6,571 and the closure are almost 2/3 matters have been closed, so 4,515 matters have been closed. Of course, closure has to be classified differently. So closure through liquidation is contributing 45%, which is not acceptable actually. But reason for the same are there. So the major reason which always I feel that there was no regime with respect to dissolution of the corporate debtor. So there were companies which had no assets, or it had only assets which are not readily realizable. And under SurfaceZine actions, financiers have sold all the assets, but because there is no process available for dissolution of the corporate debtor, those companies were there and unrealized, unrecovered claims were there. So during earlier years, I would say 17, 18, 19, those companies are also coming into CIRP and getting closed. And that is the reason whenever there are no assets or no assets which are readily realizable, those cases went into liquidation. And that is the reason, if you compare the last 6 years data, you will find liquidation is on a higher side. But I am sure if you compare, say, after 2 years, if you compare the last 3 years data, then liquidation would be on a lower side. And one interesting amendment which IBBI brought that if RP is not able, I won't say able to complete, but if a situation wherein CIRP is not getting any resolution plans and company is going into liquidation, then RP won't be continuing as a liquidator. So as an RP, now we know that if I won't be able to complete the process, I won't be continuing as a liquidator. So as an RP, I will try my best to bring in the resolution. Some fee structures were like that. So sometimes it was a situation wherein a liquidation was giving a better fee structure to the resolution profession. That could be possibility that RP were not trying their best for getting the resolution. But because of this change, now you have given a clear mandate that if RP is not able to clear the CIRP getting resolution, then liquidator would be a separate person and not the one who has conducted the process as an RP or IRP. So closure through approved resolution plan is 678. 15% cases are getting resolved, and as we are aware now, all the NCLTs are having a full strength. So and even they are having a mandate for addressing the matters of the resolution plan. So initially it took longer period of time, even there were no precedents in place. Lot of things were getting evolved, so resolution plan approval were taking some time, and that was the reason resolution applicants were not very keen to participate in the process. Still 15% is a decent rate, and over the period of last 2 years it has increased like anything. So we don't have any official numbers as of now, so that I don't want to speak on those. But unofficially, I know that this rate has been doubled. But as soon as official numbers are published by RBI or say IBBI, then definitely it will give a clear indication of improvement in the closure through approved resolution plans. Average time that yielded plan 512 days, of course, on a higher side, but as we said, in initial period it was taking a longer period of time. But now, because the regulations, the law has matured. A lot of precedents are there. A lot of expert people are there. Even bankers have grown up in this field. Earlier, they were also not very well versed with IBC provisions. Now, almost all banks are having a dedicated department whenever the matter is admitted into CIRP. The matter which is being handled by the recovery branches, that it gets transferred to their department, which is having in-house expertise with respect to IBC law. So quick decision making is now happening. So even in earlier time, resolution was taking 2 months, 3 months time from their higher ups for getting clearance, but now things have changed a lot. This is the asset value of the corporate debtor revised through resolution plan 1.69 lakh crore, which is it is 34.90%, 34.30%, which is actually a good number. So it is improving day by day. And one of the most important thing that I would like to address, that IBC has actually brought a discipline amongst the corporate debtors. The total number of cases that have been officially reported withdrawn prior to admission is 26,518. So total cases which we saw in the last MIS, total matters admitted to CRP 6,571. 4 times 26,518 matters were actually withdrawn prior to admission of the CIRP. So now borrowers know that if my company is going into CIRP, then ultimately I would be losing control over my company. So that status quo has been challenged by the IBC, because earlier under by-default regime, the company's promoters were never giving charge of the company. They were remaining in the decision-making positions. But now they know that if I default and my company is admitted to CIRP, the process would be handled by the IRP, RP, and COC would be ultimate controller of the process. So so IBC as a tool has actually brought a discipline amongst the corporate debtor. Of course, we know that it's not a recovery regime, but operational creditors are sometimes taking the advantage of the IBC provisions, and they are filing the application for recovering their money. Mostly Section 7 applications, though it is ultimately for the default and ultimate goal is to get the money back. But bankers won't find CIRP application for small defaults. So in a good way, under COVID, when government increased the threshold from 1 lakh to 1 crore, in a way it has eliminated those cases like initiating CIRP for the recovery, because 1 crore is a larger default, and if some company is not paying operational creditor to the tune of more than 1 crore, of course, even there is a definitely early warning signal, and if some OC matters are running, then bankers should actually be alerted to today it's OC, tomorrow it may be FC. So yeah. Recovery until September 23 under IBC is 3.16 lakh crore, and 808 cases have been resolved. So you can see just a perspective here. This data is of June to 2023, wherein 678 matters were resolved, and here 808 matters by September. So you can see almost 150 new matters were having a approved resolution plan in those 3 months time. So as I said, because of the full strength of the NBF and this NCLT benches, now resolutions have become faster than the earlier regime. Broadly, I will summarize what were the challenges faced by the bank in managing non-performing assets prior to implementation of the IBC. I think I have already summarized. Inadequate legal framework, as I said, SICA, BIFR, RDDB, FI, Companies Act, SARFAESI, etc. had a framework, but it was not that effective, because the IBC is categorically designed for the resolution. These codes work more or less with respect to the recovery. And plus different regime with different legal authorities, legal forums, it was taking longer period of time. Lengthy debt recovery processes. Of course, initially SARFAESI was very effective, but as the time progresses, borrowers also became smart. Of course, legal system is like that. As an advocate, if I am on this side, I will penetrate law in my favor. If I am on other side, I will penetrate law in other side's favor, right? So that is the reason that people started exploiting the lacuna of the SARFAESI, and that took longer period of time for getting the recovery under the SARFAESI. So lengthy debt recovery process was one of the hindrance, and ultimately it was deteriorating the assets of the companies. Inefficient recovery mechanism. Important thing, lack of professional expertise, and of course, since all are insolvency professional attending this workshop, so I can proudly say that the IBC has actually brought professional expertise into the system. As I said, banking is not all about recovering the money. Ultimately, bankers are focused more on giving credit to a industry which is eligible for the credit and which is having potential to grow. So ultimately, the credit is the major bank's business. And that is the reason they are not having a legal expertise with respect to this, and they were dependent upon the external legal support. There was no profession as such which was categorically focused on the stress asset resolutions. And under IBC, those through IPAs, now it is a specialized profession wherein people who are having understanding of this law, because of course clearing IBBI's limited insolvency exam requires a lot of study. So with her good studies plus minimum 10 years of experience at managerial level or into the profession, and ultimately it's not one of the services that you are giving to your client. Actually, it is a full-fledged profession. If I am into insolvency field, then it's 24/7. I have to be there, ever evolving. So if I don't remain updated even for a month's time, it would be very difficult to manage the processes. And on a daily basis, hundreds of documents are coming, and different interpretations are coming in place. Recently, now the personal guarantee regime has opened, so it is going to open a plethora of this. So ultimately, for even everyone is learning. As a bank, financial institutions are also learning that how to recover through the IBC and how to get the best resolution after the IBC. So yes, so professional expertise is out there. So earlier, lack of professional expertise has been addressed under the IBC. Absence of time-bound resolution. Earlier regimes were not having any specific time-bound situations wherein within this many days you have to complete this and like that. Here, 180 days, each and every day has been defined, and so as an IRP, RP, our role is very much categorically defined that you have to perform so much of duties. And as we know, we have been governed by the IBBI through IPAs. Of course, NCLTs are also taking the work of the IPs very seriously. And yeah, we all are not formally reporting to COC, but as a CEO, you have to address the queries of the committee of creditors. So that there is a lot of supervisions, a lot of monitoring, regular compliances, and the most important thing, approve this revalidation of your AFA. So as a company secretary, chartered accountants, cost and works accountant, we have got our certificate of practice. It is valid for lifetime. Here, every year, you have to demonstrate that you are a compliant professional, and then only your AFA will get renewed. So yes, with expertise and this time-bound resolution closely monitored, it is giving good results. Lack of all creditor participation that we discussed. Prior to IBC, whenever there is a consortium lending, JLF, the banks were not coming on the same platform, and they were always trying to recover their interest. But now through COC, all have to participate, plus decision making requires 66% voting share, so majority will decide the outcome. COC having wide powers, it's a public kind of an organization because it has to take care of the interest of all the stakeholders as a whole. Now everyone has to participate, because if you don't participate, then ultimately decision making done by the people who are participating, it would be binding on you. So as a bank, no banker would afford to not to participate in the COC meeting. And we saw in that data that prior to enactment of the IBC, the recovery rate had dropped down to 3.9%. So limited recovery success was there, which has been addressed by the IBC. So what were the challenges have been addressed, and ultimately these are the highlights. So timeout resolutions, transparent and predictable insolvency resolution process. So as I said, 180 days process is clearly defined. It is given in the code itself. Bankers are also aware, everyone is aware, and even OCs are aware nowadays that what would be the process and all. Highly transparent. Insolvency professionals are required to report everything on a monthly basis. All appointments has to go to the IPAs, several applications going into NCLT for several decision makings. So it's highly transparent process. And because of transparency, predictability, now a better results one is getting through this process. All creditor participation, yes, that is in fact giving a good validation. And whenever, so as I said, now all banks are having dedicated department with respect to the IBC matters. So they have got in-house expertise and in large matter. So if I am dealing with some bank and those officers have dealt with some different matters, he would be bringing the experience of those matters and the results of those matters, and he would be giving a good valuation. So I always encourage and I always push committee members to come prepared in the CUC meeting. So that is the reason we are giving 48 hours minimum period of notice so that they can come prepared. So I always encourage them that, see, if you don't come prepared, my job is going to be very easy, because you are going to read the notice agenda item in the meeting. So I am going to drive the entire committee meeting. But if you come prepared, then ultimately you would be able to give me some input, some advice, that what other alternatives are available. If as an individual insolvency professional or as a group of insolvency professional, we might have participated into say n number of processes, but as a banker, they would be having exposure of 10x matters. So if they are coming up with some different kind of a perspective, it will be value addition to the process and to you as a insolvency professional. So always encourage committee members to participate in the meeting. So I see whenever you share, for example, RFRP document, so draft RFRP would be running into say 70, 80, 90, 100 pages. They won't be reading, but see, if they read, then they can point out something that, okay, fine, let us address this, we can do this, some different options are available, combinations are available. So ultimately, always encourage committee members to participate. The ultimate goal is, of course, maximization of the value of the assets. Again, here, the role of banker is important, because we as an IRP or RP or as a liquidator would be having experience with respect to that company of say, if I am an IRP of new starter, if I have been continued as RP, then I would have what 4, 5, 6, 7 months experience with the company. As a liquidator, some more what. But as a bank had originally funded the account, they had done the credit due diligence. Subsequently, credit renewals would have taken place. Regular stock audit reports would be available. Reviews might have been performed. Agency of special monitoring might have been appointed, so their reports may be available. So the see, as an IRP, RP, we should ask for the maximum information from the banker, and you have to demonstrate that trust. That's the more information you share, ultimately the better information memorandum you will be able to prepare, and the more better value proposition you will be able to bring in. Plus, as a banker, if as a bank, I have funded this say metal industry, and it has turned into a bad loan, then I also have a good accounts into the metal industry. So with a good teaser memo, if you can approach the bank and you can say, you please identify your good customers and you please showcase this teaser to them, so that the more number of people can come. See, by mere publishing of Form G, it's not going to help. So as a professional, tell, we are also not tracking which all Form Gs are coming. Unless you are having that focus area that you are working for someone, or you are having a mandate that to identify some industry or something like that. Otherwise, as a professional, we are also not tracking Form G. So mere publishing of Form G. So law says you just publish Form G, but you publish Form G in 10 newspaper, you won't get a single resolution applicant, prospective resolution applicant. So you have to penetrate your network, meet investment bankers. In my personal experience, because I am having a good networking with the investment bankers, I try my best to showcase the teaser. See, information memorandum is a legal document which required a non-disclosure agreement, etc., before sharing the information. But you can prepare a teaser, a trailer of a movie, so you can share it at a mass level and attract the interested people. So approach investment bankers, approach the committee members, tell them that please circulate this amongst your other good clients, so that the more number of PRs you get, it would be a better competition, and ultimately you will get the best recovery out of the resolution. If you have got more number of people interested in the company, then you can also deploy a challenge mechanism, intercept bidding, Swiss challenge, something like that, and in order to improvise the bids from the different resolution applicants. And yes, now so we are also having that option to earn incentive from the realization. So through efforts, if you can able to recover more than the fair value, a good incentive is there. So as a resolution professional, we should strive our best, because ultimately, though we have to comply with the law, regulation, rules, etc., ultimately the profession says that you have to bring some good resolutions. So you have to wear a hat of an advisor of a merger and acquisition, because ultimately you have to identify an entity who should suitably acquire this trust unit. Structured process, 1, 2, 3, 4 till 180 days, what we are supposed to do. Experts, insolvency professionals, then cross-border insolvency will be coming soon. It has enhanced recovery of NPAs, and yes, it has strengthened the credit discipline like never before. And in turn, there has been an investor confidence, and that was one of the reasons of increasing the ranking of India as a country, because now investors have got confidence that my money is safe, even if I have invested something and that venture fails, I have a mechanism to recover my money back. Plus, as an investor, I know if my venture fails, there is an exit route available, because prior to IBC, it was very difficult to exit from the business. Now through IBC, if my company doesn't work, and so I can go into voluntary liquidation, or I can come up with Section 10 and I can sell off all my assets and repay my liabilities and exit from the business. Any questions so far? I think this is just a narrative, so I don't think so there would be any questions. So now coming, I hope we have set the tone for coming through the kind of topics which are allotted, like, so it's discussion on prudential framework for resolution of the stress assets. So this was the RBI circular. So few minutes back, I said that after the introduction of the IBC, the RBI came up with a direction, and like those 12 companies were compulsorily put into the CIIP framework. This was one of the landmark circular of June 7, 2019, which defined a prudential framework for the resolution of the stress assets. So at the beginning, I said I don't want to dwell much into the nitty-gritty of the circular, because we all can read the circular and understand the same. But the fundamental principle underlying this new regulatory approach was focused on 5 or 6 things. One, it's early recognition and reporting of default with respect to large borrowers by banks, FIs, and NBFCs. It was a proactive approach. You don't need to wait for the ultimate default to happen, the accounts turning into NPA, and then you start taking actions. It says early recognition and reporting. Then it also says complete discretion to the lenders. So lenders were empowered. So like through committee of creditors, they were empowered. With regard to design and implementation of the resolution plans, in separation of earlier resolution schemes, so X4S, STRs, 525 schemes, etc. So those schemes had objective criteria and no deviations were available, and you have to follow that schemes. And if your account is not fitting into that scheme, then it's not possible to work out restructuring. Here, a good discretion was given, because as we know, resolution plan, commercial system, you cannot challenge. So COC is empowered to approve a resolution plan below liquidation value and to reject a resolution plan above fair value. So they have been empowered to take the best decision in the interest of all the stakeholders. This circular has brought a system of decisiveness in form of additional provisioning for delaying implementation of resolution plan. So if bankers delayed, so that circular category says you have to put all companies into CIRP, this listed companies into CIRP, and you have to implement the plan within 180 days. If you delay, then you have to make a larger provisioning. So they were penalized. So it was incentive that completing the resolution within the time bound manner, you would be safe from making additional provisioning. So ultimately, your balance sheet won't be getting that hit by the additional provisioning. Withdrawal of assets classification, dispensation on restructuring, future upgrades to be contingent on a meaningful demonstration of satisfactory performance of the reasonable period. So yeah, the upgradation option was available that if resolution plan which has given a repayment plan, if it is giving 6 months, it has been paid on a regular basis, then you can upgrade your account. It was in line with the Basel Committee norms, so they were making it in line with the Basel Committee provisioning norms, and it mandated for entering into inter-state creditor agreement, which initially and creditors were not coming on the same platform. Through this circular, RBI mandated them to come on a same platform. As we are aware that ultimately default, then Section 7 talks about default. There has to be a debt and there has to be a default. Then Section 7 is initiated. Prior to that, bank was taking action only when account is getting turned NPA, so non-performing assets. So NPA classification, etc., not very much of relevance as we as an RP, but it is important if you are practicing as an advocate. Plus, if you are advising any resolution applicants, then understanding of this classification is required, because if you know what kind of provisioning bank would have made on this account, then based on that you can structure your resolution plan, because you can demonstrate that, see, fine, through this recovery it would add to your bottom line directly, because if it is 4 or 5 years old NPA account, 100% provisioning has happened. So ultimately banks has taken the entire hit. So whatever money coming through the resolution plan, it is ultimately adding to the bottom line directly. So as we know, substandard, doubtful, loss assets, I think all are aware, but NPA for a period of 12 months is called substandard. Then it becomes doubtful, and then it is getting classified as a loss asset. These are the IRAC norms. So the doubtful assets get provisioning first year 25%, up to 3 years 40%, and more than 3 years 100% provisioning will be there. So any NPA which is more than 1,000 days old, usually it has to be provided for 100% on the bank's balance sheet. What was the purpose behind this circular? So these directions were issued with a view to providing a framework for early recognition, reporting, and time-bound resolution. So prior to this, there was no system, a formal system. See, systems practically were available, monitoring was happening, but early warning signals, early warning identification, early identification and reporting, it was not mandated. So this circular introduced the classification before NPA. So SMA 0, SMA 1, SMA 2. So earlier NPA, if your account remains in a category that borrower is not paying, then after 90 days you would be, just a second. Sorry. So after 90 days, it was getting reported as an NPA, but this circular brought classification prior to NPA. So SMA 0. So within 30 days, SMA 0 classification you have to award 30 to 60. Bucket 2, it is SMA 1 and then SMA 2. So all banks had to put a system in place and they have to categorize the accounts into SMA 0, 1, 2, and it has to be reported through CRILC. So this was something which actually brought good impact and paradigm shift with respect to the credit monitoring. So the central repository of information on large credit was prepared. All banks having exposure in any account more than 5 crore, if that account is going into SMA 0, 1, 2, they have to report it with the CRIL. All banks are a member of the CRIL, so that though my account has not shown any stressful signs. But if other co-lender's account has shown that stressful sign, then I would be alerted. So the CRIL actually brought a good system in place. See, CIBIL is there, but see, CIBIL, you check CIBIL only when a new underwriting happens or a renewal happens. The CRIL is a real-time database. Every month a reporting has to go. So for all those accounts which are having exposure more than 5 crore, under CRIL in a real-time basis, a reporting would go that the fine, this lender has classified this account into SMA 0, 1 or 2. You can take an appropriate proactive steps. Here I have tried to summarize this detailed circular. So I'll quickly go through what was the purpose behind this framework. So it was issued to facilitate early recognition, reporting, and timely resolution of the stress assets. So lender to classify assets as special mention account upon the default, and they have to report it with the CRIC. The circular talks about the implementation of the resolution plan, wherein the lenders were required to initiate a resolution plan upon default with a review period of 30 days. Intercreditor agreement has to be there, so it was mandated, and resolution plan implementation in cases with multiple lenders. The resolution plan implementation timeline set at 180 days from the end of the review period. There is an independent credit evaluation, ICE, was required for restructuring, change of ownership for accounts with exposure of more than 100 crore and above. Condition outlined in the resolution plan implementation, including documentation, etc. So it has to be monitored through the independent credit evaluation agencies. If there has been delay in implementation of plan, then additional provisioning, as I said, so the bankers were kept on their toes with respect to the implementation plan. So if it doesn't implement, then a higher provisioning was restricted. Then a detailed provisioning prudential norms were also guided through this circular. Supervisory review was there. So stringent action against lender concealing account status. So if anyone, if as a lender, if my account is falling into SMA 0 and if I don't report, ultimately I am giving a wrong signal to my co-lenders. And if such situation arises, such things identified, then bankers are getting penalized. Lenders are required to disclose the resolution plans in the financial statements. Certain exemptions were there, specific case exemption from certain provisioning, including MSME revival, and natural calamity restructuring. As I said, previous scheme of stress assets were withdrawn, JLF were discontinued, and ultimately, from 2nd April 2019, the lot of all major focus was given for the resolutions rather than simple recovery. This is a summary of the prudential norms provided into that circular. I will quickly take you through those norms as well. So that circular actually gave a broader objective mechanism for identifying the stress situation. So prior to that, all banks were having their in-house risk management policies, and based on that, they used to identify the accounts as a early warning signals and all. But with these circulars, the RBI made it objective that these all parameters each and every bank are supposed to track, and based on that, they have to identify accounts into the EWS. So default is a key indicator of any financial difficulty. Yes, we all know that. Other indicators include delisting of securities, insufficient cash flows, non-performing status of credit facilities, internal credit rating, system assessment. Banks were directed to develop in-house rating as well. So any exposure above 5 crore, it has to go through the in-house internal rating mechanism. So not only external, you have to have an internal rating mechanism system in place. There was a provision with respect to the additional finance. So additional finance treated as standard during monitoring period if satisfactory performance is shown. So many a time it has been seen that accounts turning into NPA, the bank's policy doesn't allow to give any additional single rupee to that borrower. Sometimes what happens, I am into a development phase. As a company, I have invested huge amount on putting my new plant in place. During that period, due to certain situation, I may not be able to service my existing loans. So I have got a sanction of 100 rupees. I have got disbursement of 70. I have spent that 70, I have put in my another 70 rupees. But now, because of some situation, I am unable to serve the current debt obligation. So that will make a banker think 10 times before releasing undisbursed amount. So now that resulted into peculiar situation because my plant facility, my new setup is on the verge of completion. I have already put all my resources and now bank is not funding me. Even sometimes what happens, bankers also know that the client is not, he is having good intention and he is having good business plans, but this is a situation issue. He is not a willful defaulter. But still the system of the banking, the policy processes and the guidelines of the RBI prohibited bank from funding those facilities because a board will ask question, stakeholders will ask question that the account turn NPA, then how come you are funding additional amount? So to save those situations, this additional finance facility was introduced in the circular. So if it is matching those principles, if your downgraded account, restructured account is performing well within the next 6 months, then an additional finance is possible and is feasible, and it is within the legal structure. IRAC norms, as we all are aware, that and on a regular basis, whenever RBI feels that there has been some concentration of risk happening in any typical area, they immediately come up with a increase in the provisioning norms for even for standard accounts, a provisioning has to happen. So detailed monitoring is happening with respect to the income recognition norms. Conversion of principal into debt equity. Under surface, that provision was always there, but no one was using that provision. Here, categorically, RBI directed that securities created post restructuring placed in the same asset classification category as restricted advances and provisioning based on the higher asset classification category on fair valuation basis. So they come up with a criteria that you should issue equity, you can replace debt with equity, and what would be the classification of those investments. They categorically come up with those criteria. Change of ownership. So Surface Act was having that provision that change of ownership is permissible, but 80 to 90% ARCs were also not taking steps with respect to change of ownership. Here, RBI put a top-down approach through this circular that conditions for maintaining standard classification upon change in ownership, they come up with the guidelines, due diligence requirement to ensure new promoter is not disqualified and meet specified conditions. Refinancing option was there, certain regulatory exemptions were given, and cases of fraud and willful defaulters. So borrower involved in fraud or willful default become ineligible for restructuring. So if a bank feels that this is a willful defaulter based on their guidelines, if they classify as a willful defaulter or fraudulent account, then this under the circular account is not permissible for restructuring. So ultimately, these norms aim to ensure transparency, viability, accountability in restructuring process, balancing borrower support with risk management. So I would say it was kind of taken from the spirit of the IBC and RBI. So RBI is not directly involving into the IBC, but through IBC, they have taken up an important aspect and they put it into the circular, and then they pushed it top-down approach to all the banks for exploring resolutions through this circular under IBC design. Any questions, anything, or shall I move? I hope we all are on same page. So participants don't have access to unmute.
Definitely, we are having, sir.
I think we do.
So I hope this talk is making some sense.
Yes, true.
Thank you, sir. So I thought I was just talking to myself, looking at the screen. So I thought that's
No, it's like that only in every session. It's like that only.
Right, sir. So this is just like any other session, or are we getting something out of the same? Anyways, now let's move to role of NARCL in the CIRP. Any idea about NARCL?
Yes, we were given a
Bad bank, right?
Yeah,
Yes.
bad man to that. So I only spoke at the beginning of this talk.
Yeah.
Any specific? So what is the difference between ARC and NARCL?
It's supported by government,
Right.
and it's only for big ticket. I think some limit is there.
500 crore. Perfect, sir. Correct. So the major difference, as sir said, and other participant also contributed, they have come up with a limit that accounts above 500 crore NSAR will be eligible to bid for those accounts directly with the bankers and acquire those accounts. But the most important thing, see, in ARC business, what happens? ARCs acquire stress assets under cash SR scheme. So if there is a portfolio worth 100 crore, ARC can acquire it by paying 15 crore upfront. So by 15% cash and 85% issuing security receipts. So these SR security receipts become investment of the bank. So the bank is actually selling those assets. It's kind of asset warehousing. The assets, the problematic assets or the stress assets are getting transferred to the ARC's books of account, and the asset, that is the advances, are getting replaced with the investment in security receipts or subscription into the security receipts. Now, these security receipts would be redeemed whenever ARC is recovering anything out of those acquired accounts. And whenever there is any recovery, those security receipts would be redeemed by those ARCs, and ultimately banks would be getting the funds. In NARCL, these security receipts are backed by the government guarantee. So if NARC fails to recover anything from those portfolio or unable to recover as per the agreed upon arrangement or as anticipated, or during the presentation they might have shown that we would be recovering 50%. If they are not able to recover, then those SR are having certain threshold guarantee from the government of India. So bankers are assured that fine, even if there is no recovery, they would be giving you the redemption of the SR. So the ARC, because before discussing NARCL, we should understand and discuss and deliberate upon what are ARCs. I'm sure many participants must have exposure with ARC business and they might have dealt with the ARCs. The ones who are not, let me just brief that the business of asset reconstruction or securitization may be commenced only after obtaining a registration certificate under Section 3 of SARFAESI 2002. The main requirement in this regard is that the net owned funds as prescribed by the RBI should be 100 crore or more. So entity, in order to getting an ARC license, it has to approach RBI, and the base criteria is the net owned funds of 100 crore. So one would require 100 crore rupees for incorporating an ARC under SARFAESI. As NBFCs, other criteria also there, fit and proper. So any Tom, Dick and Harry showing 100 crore and saying, okay, fine, I want to incorporate an ARC and give me the license. No, that is not possible. The promoters have to demonstrate the fit and proper criteria. You have to show your managerial team the expertise, because this is a specialized business, stress assets resolutions, and as we discussed at the initial, for any robust economy, a proper structure of resolving stress asset is essential. And so ARCs are special purpose entities having expertise into the resolution of stress assets. So yeah, licensing norms are difficult. Initially, licenses were issued quickly, but today's scenario, getting ARC license is a tough task. In this chart, I have tried to simplified that what is the role of the ARC. So securitization of financial assets and issuance of security receipts. As I said, if as an ARC I am acquiring portfolio or a bank is selling some portfolio, I would be paying something in cash, upfront cash, and balance I would be issuing security receipts. And ultimately, after recovering out of those assets, I would be redeeming those. So acquire a financial assets by issuing debentures or bonds or by any different other agreements. Realize the same and redeem the security receipt issued by the QBs, so qualified buyers. So as an ARC, from where I would be getting money, if I have to pay 15 rupees, 15% upfront to the banks, I would require some investors. So I, as an ARC, would be getting money from issuing debentures. Sometimes ARCs are also having alternate investment funds. So based on that, they would be having the resources, and then based on those resources, they would be bidding for the acquisition of the portfolio. Reconstruction of financial assets. So ARCs are having a legal provisioning under SARFAESI that after acquiring account, under SARFAESI Act, they can take measures and they can also bring change in management. So during the resolution process, they can change the management, they can put in their own people or industry expert to manage the company, and during the process for identifying a good buyer. So what we are doing into the CIRP framework, those such provisions were available under the SARFAESI. But of course, because ARCs are like a recovery agent, they always felt that they should have a legal expertise with respect to the Indian legal system. And ultimately, whatever legal issues are there, they would be addressing those legal issues, and they try to clear the assets from the legal incumbrances, and then they were selling those assets through auction. They were never exercising the opportunity or possibility given under the code by putting change of management and running the business, or even restructuring the debt. The data says that whatever acquisitions ARC has taken, around 85 to 87% recovery is through SARFAESI auction only. They have hardly used the mechanism of putting change in management and then bringing a new buyer and taking the company as a going concern. So it was never used or hardly used. Of course, in CIRP now, a lot of release and concessions are available. So under CIRPs now we are getting resolutions as a going concern. So ARCs were also empowered to put in private treaty, private sales, settlement. They can take possession of the assets as per the SARFAESI actions which banks were taking. But in bank, as I said, banks are not having a dedicated department with respect to the recovery or resolutions or taking legal actions. ARCs were incorporated for doing this business, so they have in-house talent with respect to all those expert people, mainly strategic advisors with respect to the legal system and how to get the assets equivalences free and selling it in the market. Enforcement of security interest. So enforcement of security interest, as we all know, interest by the security creditors without the intervention of the court. As bank does, even ARCs can do the same way. They can repossess the property and they can auction. They don't need to bring the orders from the court. Other functions: to act as an agent of the bank or financial institutions for recovery, act as manager of the secured assets appointed by the lender, act as receiver appointed by the court. So there is also a concept of asset warehousing, where in ARCs being appointed by the banks for specifically advising them on the resolution of the stress assets, and they do also transfer the portfolio for certain time period to those ARCs. So they give opportunity of say 6 months that you please try to recover out of the 6 months. If you are not able to, then we will get the portfolio back on our books. So that is also permissible. This is a broader structure. What happens ultimately? The borrower approaches the financial institutions for financial assistance, giving their security as a collateral. This is a normal lending transaction. Whenever there is a default, bank, after trying the recovery from their level, they feel that they should not waste time, energy on the recovery. So they have an option to transfer those secured assets to the asset reconstruction companies and getting cash upfront. In turn, ARCs, from where they would be getting this cash, so they would have qualified buyers who would be putting cash into the asset reconstruction companies, and in turn, ARCs would be issuing them security receipts. So here also they would have issued security receipts. Here they would also have issued security receipts, and ultimately whatever recovery has happened, they would have to pay return to these qualified buyers. So ultimately what happens, they usually charge a management fees plus incentives. So whatever they recover in a similarly like liquidations within 6 months, within 12 months, within 24 months, the more recovery, the better incentive one as a liquidator gets. Similarly, ARC is entering into such kind of agreement wherein whenever there is a recovery in a quicker possible way, they will charge a higher management fees and all. So under the SARFAESI Act, the ARCs were designed for this. So the act is in detail. Like here I have tried to jot down the major points. The registration and regulation of the ARCs by Reserve Bank of India is through SARFAESI, facilitating securitization of financial assets of banks and financial institutions with or without the benefit of underlying securities. It promotes the streamlined transferability of financial assets by the ARC to acquire financial assets of the bank and financial institutions through the issuance of debentures, bonds, and any other securities. Yeah, we discussed. It's entrusting the asset reconstruction company to raise funds by issue of security receipts to qualified buyers. So if any company is approaching me as a qualified buyer, then I would be skeptical whether I should invest or not. But under ARC, it is governed by the RBI. They have created a proper trust structure so that the investment into the ARC is a safer call, well governed by the RBI, and RBI do have a close monitoring of the functioning of the ARC as well. So by the regulated entities, it is facilitating ARCs to get a good number of qualified institutional buyers. Facilitating the reconstruction of the financial assets which are acquired while exercising power of the information of security, change of management, other powers which are proposed to be conferred on the banks and financial institutions. So it has given different rights through which they can restructure the acquired assets and they can explore the best possible option for realizing the highest value out of the acquired assets. Presentation of any securitization company or asset reconstruction company registered with RBI as a public functional institution. So ultimately, the ARCs were licensed to do the business of acquiring the stressed assets and resolving those assets and getting the highest value maximization out of the same. So kind of function which we are doing, we are also into administrating the stress asset, taking help of the committee of creditor and identifying the best buyer and ultimately selling the assets company as a going concern to those buyers. Similar role ARCs do have, but ARCs being a larger institution, they can deploy their own funds, plus they can have access to the qualified buyers. So that in a way, it is a larger kind of an institution which is into the stress assets. Plus, the RBI guidelines is whenever any bank is in the process of selling any portfolio, after identifying those portfolio, they have to showcase that portfolio to all the registered ARCs. So that is how it should not be like that. I am comfortable with say XYZ ARC, I would be dealing with those ARC only. No, RBI mandate that all portfolio has to be showcased to all the ARCs, and then based on the EOI, the ARC would be participating and the bidding for the portfolio. So similarly, the way we do the auction and the liquidation, the same way banks are showcasing the portfolio to the ARCs, and then there would be a bidding process for acquiring those portfolios. ARCs being expedite entities, even if there is no showcasing of portfolio, they can do and they are legally empowered to do a non-binding offers to the banks. So if there is any stress asset, if they have identified, or even if some investor is there who is interested in acquiring that company, then through ARC they can come up with a non-binding offer. They can propose the bank that fine, we want to acquire this portfolio at so much of price. There is a possibility of Swiss challenge, etc., and ultimately such portfolio can be transferred to the ARCs. Yeah. Any question with respect to ARC?
Sir, can you just explain one more time the transaction which you were talking about, like the binding offers? Because you said,
Non-binding
like,
offer.
suppose
Non-binding offer, yeah.
non-binding offers. Suppose if in any bank, if an investor is interested in an asset which is less than 100 CR, and suppose he wants to acquire that asset through a ARC. Hello.
Yeah, absolutely. So that is possible. Ultimately, ARCs are licensed to acquire stress assets and resolve those assets. So that is their core activity, right? So
Right.
they can very well proactively identify any stress asset, and then they can approach the bank and they give non-binding offer. So it is not binding on the bank. So it is like I am just giving an offer that, see, I am interested in acquiring this asset. Would you be interested in selling? Then see what happens. If bank has taken enough efforts to realize out of those stress assets, then they would always say, okay, fine, let us enter into this arrangement, because they know if there are 3, 4, 5 failed auctions and they know that this asset won't be sellable. Plus, they are investing a lot of time, energy, efforts on coming up with auction and all. So if they feel that ARC is giving me a better offer, then they will definitely say. But nowadays, what happens? Usually, banks ask for the upfront cash. So that is the limitation of the ARC.
Right.
Because bankers also know that if we go into security receipt model, we may need to wait till 5 years, because officially ARCs are having period of 5 years for redeeming the securities that they have issued as us, right?
Yeah, because nowadays none of the banks are going for 1585 scheme.
Absolutely.
Because the main challenge is the SRs and the management fees, which becomes
Yeah.
a big cost
That-
for the banks.
Yeah.
And earlier also there was the provisioning thing. The provisions were not getting hit.
Absolutely.
So even that is a major challenge, and that's the reason banks are not interested or that keen for going for SR, kind of a structure.
Yeah.
Uh,
Very true. Very true. So that was the reasons that ARC business could not flourish for certain
yes.
period of time, because capital
Right.
is limited.
Yes.
You have got
So
100 crore net worth fund, but it's always locked. So you
yes.
don't have capital to pay 100% cash. Because
Right.
obviously, if I pay 100%, even I will take some time to recover out of the same. And I have
Yes.
issued debenture as an ARC, so I am having a fixed obligation on those debentures.
Yes.
That actually blocked. But because of NARCL, now that structure is again reopened. Because tomorrow NARCL would be coming and acquiring your assets compulsorily under the direction of
Right.
So
Yeah, because
so
again
that-
it is central bank
yeah.
guaranteed, right?
And there is a Swiss challenge mechanism available that I am offering you. You go to the market. If you get better deal, fine, give me option to match the deal. Else, you have to give me at my deal. So,
Right.
so that is the reason now again, rather than waiting for NFPL to come and acquire, now banks are approaching ARCs again, and then they are also settling at 85-15. So some of the acquisitions which I have recently witnessed, within
Okay.
85-15%, now things are moving.
Okay.
So
And now
NAR
actually this is JFM. This period is especially more of the deals coming for ARCs
Absolutely.
because
To
banks are
improvise the
trying to.
balance sheets. Yes. So this is the correct time for approaching any
Right.
bank for acquiring the portfolio.
Yes.
So nowadays, so we
Very
are getting call from the bankers that
right.
we have got this account. You please have a look at the same.
In fact, recently I had a discussion with one bank which is actually into CIRP. Sorry, that company which I was discussing with the bank to CRP. The CRP process is already on. In fact,
Your voice is not coming, sir. I think some voice issues are there. Anyways, so as sir rightly said, January, February, March is actually an appropriate time. So if you are seriously interested with respect to any account resolutions, and if you have got any investors, any acquirer, then meeting bankers, they would definitely help you the best for getting the resolution. NARCL, the Honorable Finance Minister in the Union Budget 21 announced the formation of the ARC AMC structure comprising two entities. So two entities were incorporated: National Asset Reconstruction Company Limited and India Debt Resolution Company Limited. Anyone can say what is this IDRCL, India Debt Resolution Company, and what is their role? So NARCL, I think broadly now we have understood that it is a large ARC bad bank with a backup from good number of public sector banks. Anyone knows what is India Debt Resolution Company Limited and what is does?
Primary responsibility of them is to resolve the asset. I mean, the resolution of that asset which is acquired by the ARC
So
is the responsibility of
So that is
IDFC.
the role of NARCL.
That is just acquiring that balance sheet, but resolution of that is done by India Debt Resolution Company, which will be employing the resolution application and doing all the processes.
True, very true, sir. So basically, it is an advisory arm of NARCL. So it engages a talented pool who are having expertise and exposure into the stress asset field. As I said during the initial talk, that networking with the investment bankers, etc., is very essential. So here they have the people who have got good exposure, good experience with respect to investment bankers, investment, different kind of set of HNIs, etc. So they are advising the NARCL on how to get the resolution. So they go into the market, showcase the portfolio, showcase the value proposition, and ultimately they scout for the investor for resolution of the state. So in a way, it's a good combination structure because NARCL will have good liaising with the bankers and they would be negotiating with the bankers for acquiring the portfolios. Along with that, whatever portfolio that has been acquired or whatever portfolio that they are targeting to acquire, in backend, India Debt Resolution Company Limited would be doing its best for scouting for the investors or the resolution applicants. So this is the structure envisaged. As obviously, no major resolutions have happened till date, but definitely the concept and that too redemption of SRs supported by government guarantee is a highlighted point, and definitely in a coming years time or probably I'll just say finance ministry has given a very good target to the NARCL for doing the acquisition by the end of March 2024. Yeah, so this is the target. Finance Ministry aims to transfer 1 lakh crore of stress assets to the bad bank by this March end. As we discussed, that NSCR has been set up with a strategic initiative to clean up the legacy stress asset with an exposure of more than 500 crore and above in the banking system. NARCL offers adaptable acquisition structures comprising of optimal mix of cash and SRs, and those SRs are also government backed. So bank can say, okay, fine, it would be redeemable for sure in certain period of time. So banks can transfer those legacy accounts and they can clean up their balance sheets. NACR's acquisition process will be administered by their financial asset acquisition policy framed under the extant guideline for asset construction companies. And NACR's investment strategy focused on aggregating the stress assets under one roof to ensure efficient resolution of such assets. So now, just a hypothetical example that there is an account with exposure of say 5,000 crore, 7 banks. You are appointed as an RP, and there is one account 5,000 crore acquired by NARCL, and you are acquired as an RP. So, what would be the major difference in those two CRPs? So, what would be the major difference in those two accounts? You can write in chat box if you are not able to.
Can you repeat your question, please?
I am throwing just one hypothetical question that there is one account with 5,000 crore of exposure and 7 banks are there. There is another account 5,000 crore exposure and NARCL is acquired that account and you are RP in those both matters. So what would be the major difference in doing the CIR process of this account?
I think COC and decision from the COC would be the easier way in NARCL.
So you just need to convince NARCL. Here, convincing 7 different member banks, of course, resolution plan, payment mechanism, security interest quality, etc. So difficult to get 66% threshold. So if account is being acquired by the NARCL, it would be easy for getting the consensus. As of now, NACL has acquired 8 accounts with loan exposure of 58,000 crore. As I said, Swiss challenge. Everyone is aware about the Swiss challenge. Another 23rd accounts are underway. So probably 30 plus accounts will be there with the NARCL. So see, understanding NARCL, it is better to focus on ARCs because as a professional, working with NARCL would be a limited opportunity because they are acquiring a large size account and it all would be backed by the larger size advisory firms and all, right? So so work remains the same. So whatever ARC is doing, NARCL is doing on a larger scale. So how acquisition of NPAs actually happens by the asset recovery company, that here I have tried to jot down so that we can discuss, we can understand, and then we can deliberate that how useful ARC platform is for resolution of any stress asset. So technically, as I said, under SARFAESI Act, the licenses were given. So among the key players in the resolution ecosystem, ARCs came forward, 100 crore of net worth fund, and then they sought the license and then they started the business of resolution of stress assets. So what they do, they identify the non-performing assets. So the lenders such as banks and FIs identify NPAs based on the criteria stipulated by the RBI. An asset is classified as an NPA more than 90 days and all. So ultimately, two ways it happens. Either as a bank, I am identifying a pool of accounts and then I am showcasing to the ARCs that, yeah, I want to sell this portfolio, you please bid. Another option, as an ARC, I am proactively identifying certain accounts and then I am approaching the bank. They find I have done due diligence and I want to acquire this account, so and so price. So this is the starting point. Transfer of NPAs to the ARCs. So once the deal is finalized, agreement is entered upon, then the account would get transferred from the balance sheet of the banks to the ARC's balance sheet. So once identified, lenders may opt to transfer NPA to the ARC for resolution. This transfer involves the sale of stress assets to ARC at a mutually agreed upon value. That's the reason showing to all the ARCs will bring a good competition and ultimately a value maximization happens. The transfer is governed by the SARFAESI Act and requires compliance with regulatory guidelines set forth by the RBI. So it is again, as an insolvency professional, we are bound to follow the guidelines of IBBI. Similarly, ARCs with 100 crore rupees at stake, governed by the RBI, they do have to follow stringent guidelines of the RBI. So due diligence before, whenever there is a portfolio showcasing to the ARCs, they were given certain non-disclosure statements and they were given certain windows for doing the due diligence, because without due diligence, what kind of legal documents are there, what kind of contracts are there, what kind of legal issues are running. See, after doing the due diligence only, they would be able to bid for those accounts. So prior to acquisitions, ARCs conduct a comprehensive due diligence to assess the quality, viability, recoverability of the stress asset. This process involves evaluating the underlying collaterals, borrower profiles, legal documentation, and potential resolution strategies. So as a professional, this is one of the quality practice area to get associated yourself with the ARC and give your services as an expert. Because as an ARC, ultimately after acquiring, resolution has to happen. So if you are associated with the ARC before the company is going into CIRP, because as an ARC, I may need to put the company into CIRP. So the due diligence of the accounts for acquiring a portfolio is a good practicing area, and ARCs do give a good remuneration to the experts. This could be a good area. And in my personal experience, I say, so when that merger was to happen, Dana Bank, BOB, etc., at that time, the entities were selling that portfolio for whatever reason, because they had certain target with respect to showing the good quality balance sheet. So at that time, a lot of ARCs were coming up with the mandates So studying those accounts, working with the ARCs closely, actually there was a deep learning with respect to finding the resolution of the stress assets. So good professional practicing area. Yeah. So once due diligence has happened, and as I said, ARCs do have good in-house talents. So they within those period of time they would do the due diligence, and ultimately based on due diligence they would bid for the accounts. Once you bid, once you declare as a successful bidder, then ultimately acquisition process will start. Upon completion of the due diligence, ARCs acquire NPA from the lender through formal agreement. So assignment deed would happen, and under that assignment, they don't require any confirmation from the borrower. The ARC would step into the shoes of the banker as a lender. So this agreement outlines the terms of transfer, including the purchase price, mode of payment, and right and obligation of the both the parties. As an insolvency professional, whenever you are handling any matter as an IRP, RP, or liquidator, and if there is a financial creditor who is ARC who has acquired account from the bank, and you as an IRP, RP, or liquidator, you must go through this document in detail, because while verifying the claim, understanding of the purchase agreement is of utmost use, because there are certain transactions which happens in the market. Say for example, on my books, I am having intercorporate debt. So I have borrowed from my subsidiary company, say for example. Now I am going into CIRP. So that of my subsidiary company would become a related party. And ultimately, as a related party, though you would be admitting the claim, but there won't be any voting right. So smartly, what people does, people sell those portfolio to the ARCs, the independent ARCs. Portfolio getting sold at a meager prices with security receipts, and ultimately the entire recovery right is assigned to those ARCs. And now those ARC would coming into the CIRP and filing their claim and saying that, oh, see, fine, I am the not related party, and they will also have a voting share. So if you study those agreement in detail, if you have done a proper due diligence, then only you would be you would be easily take the decision with respect to whether those ARCs to be classified as a related party or non-related party. So real life situation would come. So after acquisition,
Can I ask a question over here?
Yeah, sir.
In the similar situation, like suppose if I am the RP of a holding company.
Yes.
And this holding company is also having a loan, unsecured loan in the subsidiary.
Correct. I have given loan.
Sorry?
Asset or liability?
Loan, advance given.
Asset.
So, can in the similar context, can my loan, but obviously I will be filing a claim for that loan, unsecured loan in the subsidiary. But can I get a voting right stating that since RP, because this holding company is into CIRP, so being the RP of this holding company, I am an unrelated person. And so can I get a voting right in the COC of the subsidiary? Because even the subsidiary has also initiated CIRP.
The company is a related party which owns the asset.
Won't get. Though both the companies are into CIRP, you won't get.
Won't get, because
So
my
you
one of
cannot
the
change-
cases is the same example wherein
You cannot change the color of the date. It is a related. Once a related party date would always remain a related party date. So here, so I went a step ahead. Even if I have sold the portfolio to the third party ARC is not at all related to me. Still, there are decisions if this nexus has been proved. See, obviously, it is case to case basis. There could be a situation wherein if that is an arm's length transaction, if ARC can prove that it is an arm's length transaction and see, I have actually acquired this portfolio paying this much of money and these SRs are laying in my trust account, etc. You have to see. But if it is a one of the transaction, it will remain a question mark. If regular such transactions are happening, so depend upon the situation. So this is, I'm just giving the perspective that while verifying such claim, you have to be extra cautious, because if you admit the claim, then the other creditors would be not happy and they would be coming up against you, and that would be a very complicated situation arising. So that is the reason. Obviously, verification of claim is the most important task with any professional, and the system is like that. IRP is supposed to do it, and as an IRP, you are not sure whether you will continue as an RP or not. So the verification of claim 7 days, that is the basically it is the premise of the entire CIRP. So one has to give the best while verifying the claims.
I agree. See, it's a related party, but since RP is an independent person, right? So whether that claim, which is being on behalf of the holding company, basis that can he get a voting right? Because I know, but obviously in the natural course, it would have been related.
Sir, he won't get. The logic is, so whenever that funding has happened, it may not be at the arm's length transaction. So here as a bank, I have done a due diligence, credit risk, etc., and I have funded. Tomorrow, intercorporate debt coming into picture, and then they are say I am having charge over all the asset, etc. So possibility that my security interest is getting hampered because of those related party debts. So that is the reason once a related party debt will always remain a related party debt. But yes, case to case basis, one has to see if you feel this RP scenario, so it is definitely a related party debt. So do we have a provision of break or we can continue?
Then we can take break.
We can.
Sir,
Fine, ma'am. So tell me at what time we should reassemble.
sir, in 15 minutes at
Uh,
3:30.
at 3:30. Chalo, just let's bear for 2 minutes. Let me just finish this. So and ultimately, after acquiring the stress assets, ultimately the ARCs are supposed to follow SARFAESI guidelines, and now so even they can take the advantage of the IBC, etc. And ultimately they would aim for the resolution of those stress assets, deploying different strategies. They would tailor the requirement based on upon the complexity of the situation, and then they can come up with the resolution plans, restructuring of loan, one-time settlements with the borrower, enforcement of security interest, sale of assets to the strategic investors. So different options are available for an ARC to realize out of the stress assets. And enforcement of security is always permissible under SARFAESI. Ultimate goal throughout the process, ARCs strive to maximize the value of the distressed assets through diligent management, strategic intervention, and timely resolution. So by unlocking the NPAs, ARCs contribute to the overall stability and resolution of the financial system. So ARC's role is actually critical. And yeah, that's it. Let's have a break and then we shall discuss further. Yeah. So let's assemble after 10 minutes, ma'am. Currently it's 3:17. Let us meet at 3:30. Can we start, ma'am? Can we resume the session?
Yes, sir.
Yes, Pramodji. Because everyone has got the video off, I don't able to comprehend whether all are there or not. But if I see SI host, can confirm. Can we start?
Yes, sir. Yes.
All right, ma'am. Thank you. So we were discussing on the how ARCs does acquisitions. Here I have summarized how practically what happens. So acquiring distressed assets, ARCs primarily acquire distressed asset, including non-performing asset and structuring of securities. Upon acquiring, what happens? So ARC may repackage them into securities for sale to investors. So I would be having an underlying asset as a stress asset portfolio, pool of assets. If it is a single account, then a single account, or if a pool of assets, if I'm acquiring, say 100 accounts for 50 crore, then I would be having the pool of assets. So in some account, I may be able to recover more. In some account, I may need to bear the entire loss like that. So the very most typical example would be of acquisition of a credit card portfolio. So it is available at very cheap prices. So the ARCs which are into retail kind of a stuff, they always focus on the credit card portfolio, because under credit card, what happens, companies, because of unsecured nature, they usually write off the entire unrecoverable amount. Then ARC is acquiring those portfolios, say 2%, 3% pricing, and then they chase the credit card holders. So because they are retail clients, giving them a legal notice, actually for them, many clients seeing a legal notice, they immediately come up for the settlement. So ARCs make a good IRR whenever they acquire a decent credit card portfolio. Anyways, so they do repackage the things, underlying assets, taking underlying assets, they issue security receipts and they offer the investor a certain rate of return based on the underlying assets. ARCs are required to create an ART. So it is called Asset Reconstruction Trust. So ARCs often establish Asset Reconstruction Trust to hold the acquired assets and issue securities. The ART issues securities to investor against the underlying distressed assets as held by the trust. So ARCs usually don't acquire assets on their and keep the assets on their books of account, because they would be having an asset light model, because their major focus would be on acquiring the portfolio and not the assets. So usually assets gets parked into the ARTs, and in turn every portfolio would be having a separate ART, and based on that, that trust would function, recovery would go into that trust, and based on that the security receipts get redeemed. SR represents undivided interest or share in the underlying pool of the stress assets held by the ARTs. So ARC issues SRs to the qualified institutional buyers or other investors, providing them with a stake in the recovery proceeding from the asset. So any individual buyer cannot acquire, because it is a highly risky asset without understanding. Even a good mutual fund schemes have to have a disclaimer that mutual funds are subject to market risk. So likewise, they are so investing in good scripts. Here, so it is a stress portfolio which banks was unable to recover, and ultimately those portfolio ARCs are acquiring, and with a focus that they would be able to recover a good amount out of the same. So investing in SRs is not allowed to individuals, so it has to be to the qualified institutional buyers only. Then redemption process. So redemption of the securities issued by the ARCs typically occurs upon the recovery of stress assets or through scheduled payment as per the terms of securities. So the ARCs do have an option to give an opportunity to the borrower by restructuring the debt. say for example, I am acquiring say 50 crore portfolio and bank was not able to restructure the asset, but as an ARC, I can do the restructuring and I can even enhance the loan. So I can even give the working capital facility if I feel that this unit is a running unit. If I feel that this unit can be revived, then as an ARC, I can infuse funds into that company, obviously at a very risk price return, high rate of return would be there, and accordingly, I can have an option to restructure the debt, fuel in more money, and then ultimately get the repayment from my restructured debt from the original promoters themselves. And whatever recovery happens based on the formula, the SRs will get redeemed. Recovery and resolution. So ARC undertake active management and resolution efforts to maximize the recovery from the distressed assets. This may involve restructuring of loans, enforcing security interest. We have already discussed. ARCs, as I said, they are supposed to do heavy regulatory compliances. As an ARC, 100 crore of net worth is at stake. RBI governed entity. So deep monitoring would be there. They are subject to regulatory oversight by the authorities such as RBI and SEBI. So they have to adhere to the regulatory guidelines and disclosure requirement in the issuance of the digital securities. Investor relations, very important, because without money, you won't be able to acquire any portfolio. So ARCs have to maintain a communication with investor holding their securities, providing updates on the performance of underlying assets. Recovery efforts, they have to demonstrate what kind of recovery efforts they are putting in and what is the flow of buckets, how the portfolio is moving, what recovery is happening, because ultimately without investor, they won't be able to acquire any further portfolio. So even if I want to resolve the account, if I want to fund the additional working capital facility to the existing account, I do require a good support from my investors. So transparency is the key. So transparency and investor confidence are very crucial for maintaining liquidity and market acceptance of the securities issued by the ARCs. So in summary, we can say that ARC play a pivotal role in the issuance and redemption of the securities backed by the distressed assets. So by acquiring, restructured and securitized distressed assets, ARCs provide investors with opportunity to participate in asset recovery and resolution process while facilitating the efficient deployment of the capital in the financial market. So what is in there for the banks? Banks can get rid of the stress assets, and through the funds which ARCs have given them for acquiring the portfolio, they can lend the money further in a good project, and then they can start that ripple effect. So the stuck amount gets unlocked and bank can reoperate with those capital and start the further funding. So ultimately, this is how that system works. So traditionally, as we know, ARCs are governed by the SARFAESI. So they have been enacted under SARFAESI. So after enactment of IBC, one precautionary situation arises, whether ARCs can participate as a resolution applicant in the acquisition or not. So initially some ARCs came up as a prospective resolution applicant and they got the portfolio acquired, but then the issue came up because under the SARFAESI Act, ARCs are treated as a recovery agent and they are not supposed to acquire the company and run the company. So the role of the resolution applicant is as such, they would be acquiring the company under the CIRP process, maintain it as a going concern, and they are supposed to run the company. Even normal CIRP process, if someone is merely interested in acquiring a fixed asset, then that is not the purpose of the code. Ultimately, the company as a going concern has to be acquired, and this relaxations with respect to section 53 is available. You can give a heavy haircut to the government claims. So crown debt concept has been altered. Crown debt has been put up on a 5th place. Why? Ultimately, the spirit of the code is for the revival of the corporate debtor, generate the employment, unlock the capital. If unit functions, then there would be a direct taxes, indirect taxes, and ultimately it will add to the economy as a whole. So the now situation arises because ARCs are basically a recovery agent. They are supposed to recover, so whether they can be a resolution applicant or not. So after some litigation, etc., on October 11, 2022, the RBI issued a circular providing the regulatory framework for participation of ARCs as a resolution applicant in CIFP process. So it was clarified by the RBI to clear all ambiguity that ARC can participate. Yes, it has come up with certain caveats, and those caveats we will definitely discuss. So now ARCs were given certain compliances that they would require certain net owned funds. So initially to set up an ARC, you require 100 crore net owned funds. But to act as a resolution applicant, they have got a different threshold limit. So I would require a minimum 300 crore net owned funds if I want to participate in the portfolio as a resolution applicant. Because after acquiring a unit, maintaining a unit would require infusion of capital on a regular basis, plus putting up resources. If I am acquiring a company under CIP, I would require a management to function. I would require a board. I would require a CEO, CFO, and other people so that the company would remain a going concern. That requires funds. So that is the reason different for participating in the resolution applicant. They have defined as different structures. So this was the matter I had just narrated. So it was a UV asset reconstruction company. In Aircel Metal, they become the successful resolution applicant, and then this issue came before the court whether that ARCs are eligible to act as a resolution applicants or not. So now through this circular, it is very much clear. So before this circular, one Sudarshan Sen committee was incorporated, and they studied that what is the role of the ARC and whether we should allow the ARC to participate under the CIP process as a resolution applicant or not. So ultimately, their focus area was to review the existing legal and regulatory framework because SARFAESI were not having the enacting provisions to become ARCs and SRA or RA. Then the various acts applicable to the ARCs and their recommended measures to come up with solutions. Ultimately, they also focus on improving the efficiency of the ARC because the legacy issue with ARC was that they are not adequately capitalized, and that is the reason they were unable to offer a good amount for the portfolio acquisitions. So how to ultimately, if they don't have a good efficiency, there won't be any investors. So it was a deadlock situation. So the committee was also given a task to research on how to improve the efficiency of the ARCs. They review the role of the ARCs as a resolution process. Under the IBC, various suggestions were invited. Business models of the ARCs were re-verified. Even some of the ARCs were put to the RBI's review because some ARCs were providing platform to the promoters for acquiring their own funds. Money, the company getting the controls of 29A, which is actually making the promoters ineligible if they are not exempt under Section 240A. So through even backdoor ARC entry, they were not permitted. So whenever RBI has a reason to believe that the ARC is being used as a platform, they have opened up a lot of inquiry on those ARCs. And finally, the report came in and ARCs were made eligible to participate as a resolution applicants. So this RBI circular actually given a broader criteria with respect to how an ARC is becoming eligible to act as a resolution applicant. So ARC have to have a specific committee comprising of a majority of independent directors. So if as an ARC I want to become a resolution applicant, then I have to have that specific committee, which all ARC won't have. So I required a committee with majority people being independent director to take a decision on the proposal for submission of the resolution plan under IBC. If needed, ARC shall explore the possibility of preparing a panel of sector specific due diligence. They can also have a panel and having people who are having expertise with respect to those industry and those sectors. Resolution plan. So with respect to control over the corporate data, the ARC after 5 years from the date of upload of the plan, this is very important. After 5 years of the upload of the plan, shall not retain any significant influence or control over the corporate data with respect to specific CIRP. So if as an ARC, I am participating in the process, within 5 years, I have to decontrolize it and I should not have a controlling management share in that revived corporate data. So I've been given as an ARC 5 years to run the business and to scout for a person to whom I can sell my stakes. Various disclosure, of course, if I am acquiring something in normal course, I was supposed to make several disclosures. Here, a specific categorical new circular came into picture, which had a heavy disclosure requirement. So the ARCs shall make additional disclosure in the financial statement with respect to asset acquired under IBC, in addition to the existing disclosure requirement. These would include the type and value of the asset acquired under IBC, the sector-wise distribution based on the business of the corporate data, etc. ARC shall also disclose the implementation status of the plan approved by the AA on a regular basis in their financial statement. Anything to deliberate with respect to the functioning of the ARC? Because now I'm moving to the SSFs, so special situation funds, which are actually connected with the ARC business, because ARCs would be getting funds from AIFs and SSFs.
The ARCs should have a minimum net owned funds of 1,000 crores to participate in the process as a RA.
6 months criteria was given for bringing it to 1,000 crore. So they were given certain thresholds after issuance of the circular. So now that threshold has been completed, and now minimum 1,000 crore net own funds is required. Perfect, sir.
So as of now, the available ARCs which are there, I think except NARC, National ARC, or Edelweiss or JM Financial, I don't think any other ARC is having that quantum of net owned funds.
Sir, Phoenix is there because Phoenix is supported by the Kotak Mahindra Bank.
Okay.
Yeah, and two more ARCs are also there. And so, yeah, they are, because of, see, this AI apps, what issue ARCs were facing, ARCs were unable to get funds through normal route like debentures and all, right?
Right.
Now, typically what happens, practical business, if I say, there would be some people, of course, interested in seeking the platform of the ARCs for acquiring the stress assets. So now with AIF, now it is giving a better opportunity, because in AIF, if I invest, my money gets blended and then it loses the source. So with AIF, with SSFs, now ARC are actually increasing their net own fund criteria gradually.
What if after 5 years ARC is not able to bring any resolution company?
Sir, in that scenario, but it is must, otherwise they would become a non-compliant and ultimately RBI would taking action on their same. But that we don't have any precedent because 5 years have not exhausted for any of the matter.
Okay.
So ultimately, even it is like compulsory, you need to exit. So it would be kind of a Swiss challenge situation would arise. So we need to see what happens. But this is the directive. You have to exit in 5 years. So what is AIF? So AIF means any fund established or incorporated, which is privately pooled investment vehicle, which collects funds from sophisticated investors, whether Indian or foreign, for investing it in accordance with the detailed investment policy for the benefit of its investors. So it's kind of a mutual fund, but a special purpose fund with good flexibility. Mutual funds are governed deeply because public at a large are investing. Small ticket size, minimum 1,000 rupees. You can start investing even in AIF. 1,000 rupees is a basic criteria. And also, whenever you are approaching mass, you have to follow stringent guidelines. Here, sophisticated investor means they are the risk takers. So even if their principal amount becoming zero, their risk category should be that they should be able to bear such losses. So the sophisticated investors are now coming up and investing into the AIFs. So there was a consultation paper which came in November 2023, wherein a special situation asset fund was created under the AIF. And with respect to the insolvency law, those funds were targeting that under IBC, those funds would be investing into the assets for acquiring. So AIFs, subclassification SSFs, they would be investing into ARCs, and ultimately ARCs would be becoming the resolution applicant for acquiring the stress assets. a detailed guidance has been given. I don't think that those detailed guidance we should go by, because ultimately it's all regulatory, and as a professional, that is not much of use for us. But yeah, connections with AIFs is essential, because if you are a resolution applicant, then for seeking investment as a resolution applicant, if I am having access to X amount of fund, but I want to acquire a larger size of company, then AIFs would be a good resource, because there won't be any fixed obligation on me, and I can seek funds from the AIFs. As an ARC, of course, tie up with the AIF is a good option, so that I can bid for the good portfolio. And as a resolution professionals, having connection with the investment bankers or trustees who are managing such trust, you can showcase your teaser, your information memorandum, and you can attract them for bidding for your company and ultimately getting the resolution. So, a good resolution professional should definitely have a good connects with different funds. So not going much into the details, so that we can have at least 15-20 minutes at the end of the session for discussing real life situation queries. So ultimately, what are the expectation of the investor or a resolution applicant from IBC? So we have seen that what were the challenges prior to IBC, how those challenges were addressed by the IBC, how RBI came up with a prudential framework on resolution of stress assets under IBC, ARC, NARCL, SSFs, etc. So ultimately, it's all about resolution. As a resolution professional, IRP, RP, or liquidator, ultimately, our aim is to get the resolution, unlocking the debt capital and putting it into the better use, right? So of course, as an investor, what would be the expectation? Value acquisition is something that everyone is looking for. Everyone wants 100 rupee asset at 10 rupees. Now, it is not practically feasible. So 100 rupee asset has to be sold at 100 rupees. So a proper value proposition document, facilitating a due diligence. Practically, I have seen whenever some company is there, one is becoming IRP or RP, that company is not functioning, then we don't take initiative. We just keep the company as it is. We prepare information memorandum, we showcase it, and ultimately we get the bidder, and they will bid for the company, and the value won't be as expected by the committee of creditor, and ultimately the resolution fails. But on the contrary, if we try to revive even a single assembly line, and if we showcase that, yeah, this company is functional, so the major difficulty which we would face is with respect to the funds. COC members won't be willing to give you any money, because they don't want to spend a single good money after a bad money, so they are restricted. But as an insolvency professional, we should have a good connect with respect to the people who can lend us interim funding, because with interim funding, a priority payment, if you as an IRP, RP are sure that assets are there, worst case scenario, even if company is going into liquidation, these assets are adequate to cover the interim funding along with the interest. For an investor, it's a good value proposition. If I do have funds, and if I lend you at a 20% and my payment is secured, only issue with respect to timeline. There could be a possibility that I won't be getting payment within 1 year, or there could be possibility I can get my payment within 6 months. Or I need to wait. If there are litigations, then it will take 2 to 3 years, even 4 years, and I'm not sure. But ultimately, if contract is there, I am having a heavy rate of interest. So interim finance is a good practice area. Having good connect in the market will definitely get you a good interim funding. And to just restart the operation, you don't require very huge amount of fund. You just need to clean up the factory setup. You need to just repair or rehold the one of the assembly, and you should restart the operation, because you just need to run that company for 4 to 5 months. And if company is functioning, you have placed your couple of people there. Whenever the resolution applicants, PRAs are coming for doing the due diligence, if they see that company is functioning, then definitely you will be able to get a good value out of the same. Because ultimately investors are seeking for the opportunities to make a good return, and they are always scouting for the value propositions opportunities. Investor wants clear resolution process. So investor always expects the IBC process to provide a clear and structured framework for the resolution of the distressed asset. This includes defined timelines. Yes, they are there. Transparent procedures. Yes, transparent procedure is there, and certainty of outcomes. More or less, if as a RP, I am doing a good due diligence of the resolution plan, because whenever I am giving compliance form H, I am signing then form H, and in that form it is one line is mentioned that the resolution plan is compliant as per the IBC. It is not defeating any provision of the code, etc. So due diligence of the resolution plan by the RP is of utmost importance. What happens whenever there are more than one resolution applicants, and out of 3 you are declaring X as a successful resolution applicant, other 2 would be not happy with the outcome of the process, and they will try to exploit something with respect to the RFRP document or evaluation matrix or the process, and they will try to exploit it in the court. So NCLT, they will come up with some intervening application and here and there, and ultimately it will be delayed. But if you have done a good due diligence of the resolution plan, then you can confidently defend your proposition. I always recommend, and I do practice. So I always remain physically present and represent all my matters. So whenever I am an IRP or liquidator, in all the application, I represent my case on my own. Obviously, whenever there is a complex situation, we need to engage a counsel. But for normal procedures, there is no need to engage a counsel. You can engage a counsel with respect to the nitty-gritties of the thing, but you should remain at least present along with the counsel, because especially on resolution plan, what happens? Resolution plan is a very detailed document, and a hearing would be wherein lot of questions would be asked. So with respect to advocate, what happens? They are expert in the legal process and the way they have drafted the petition, and they can take up the court with respect to the specific area which has been there in the petition. With some questions arises. Actually, just 2 days back, in one of the matter, I was a resolution professional, and the resolution plan matter was up for hearing. I was there. So court specifically wanted to understand what kind of business the corporate debtor was doing. So you cannot expect from the advocate that he would be knowing what kind of business the corporate debtor was doing and what is their balance sheet. So they also asked what were the intangible assets, how you have arrived at this valuation. So obviously valuation report, no advocate would have gone through. He will just point out that under form H, this is the fair value, this is the liquidation value. So one adjournment actually costs heavy amount, because even if there is one adjournment, your matter is getting listed for the next month. Entire recovery and resolution would be delayed by that 1 month, and you never know within that 1 month some interrupted applications are coming and it would be hampering your process. So in order to demonstrate a good professionalism, you should be there in all the hearings, especially of the resolution plans. And whenever there is section 30 subsection 6 application, you should be there and represent case on your own. You will definitely get results very quickly. Legal certainty is what the investor are looking for. So investor seeks legal certainty and protection of their rights as a resolution applicant. So yeah, it's there in the code. They expect IBC process to provide a robust legal framework that protects their interests and ensures enforceability of the resolution plan. So immunity is there, clean slate theory, etc. is there. But yeah, one of the issue that we are facing, and everyone in future, if they have not completed any resolution, they would fetch. So implementation of resolution plan itself is a task, because NCLT always put in the order that we are the adjudicating authority and we don't have jurisdiction over all the forums. So that as a successful resolution applicant, SRA has to approach to all the authorities for putting the plan for implementation, and it takes good amount of time. So within code, it is given that 1 year's timeline is given for implementing the plan. So as a professional, it is another practice area for advising client for successful implementation of the plan, because successful implementation plans require a detailed knowledge of the IBC plus a legal understanding, because in various forums you need to approach. If I want my income tax dues set of carry forward losses I want, then I have to approach a proper assessing officer and I have to represent my case, and accordingly I will get the set of and carry forward if I have a card company as a going concern. Everywhere, even if it is a GIDC, like any industrial development area, and some dues are there, you have taken a haircut or you have waived off entire dues, but to get your name registered with those industrial development corporation, you need to approach those authorities. You have to explain them the provision of the IBC. So likewise, though legal clarity is there, but it's still evolving, and there is no common system wherein any authority can access, okay, fine, this case has been resolved under IBC, so we are supposed to give this much of relaxation, etc. The funny part is that even ROC, whenever you approach ROC, they are also questioning you a number of things. NCLT is the authority for all companies law matter, but still to remove the old detectors and to putting the new detector in place, that itself is a challenging task. So as again, system is evolving over the period of time. We will have a unified system wherein through approval of the plan, automatically other things will take place. But till the time it is not settled, let us let us take it as an opportunity, professional opportunity, and then let us give our best professional advisory services for the same. Level playing field, investor expects a level playing field where all resolution applicants are treated fairly. Of course, that is our duty as a resolution professional. You cannot give preference or any advantageous position to any of the resolution professional. You have to be very fair. You have to give equal opportunity to the participant in the process. Transparency, impartiality, these are the basics of our profession. Access to information, very important. Try to get maximum information of the corporate data so that you can put it in the beta room so that a due diligence can happen, and tomorrow the successful resolution cannot say that this information was not given to me and that is the reason my plan stands changed because this was not available to me. So investors require access to relevant information about the listed asset, including its financial position, liability, potential risk. They expect the process to facilitate due diligence and provide access to necessary information. So always dedicate one staff at the factory premises if it is there, functional, so that during the due diligence he can facilitate the PRS and he can demonstrate each and every plant, machinery, whatever is there in the information manner. He can tell that, okay, this is it. See, tomorrow definitely you will have a disclaimer that due diligence rests with the acquirer and like that. But see, practically you are projecting this company as a value proposition. So it is our duty as a resolution professional that you should clarify all the doubts of the PRS. The more confidently you will be able to clarify their doubts, provide information, documents, details, the better resolution plan you will get. Supportive regulatory environment, investor expects a supportive environment that encourage investments in the distressed assets. Yeah, it is there actually. NCLTs now putting petition before NCLT and getting listed. The time has shortened like anything. Matters are coming on the board within 2 days, 3 days time. You just have to be clear with respect to the process of the NCLT, and yeah, within 2 to 3 days time, your matter will get listed. And even they have got direction with respect to clearing the pending cases at the earliest. Section 7 matters, 9 matters, resolution plan matters, liquidation matters are being heard on a very shorter interval basis, and they are making the decision making very quick. With any SL, if the date of default etc. is recorded with any SL, that it is then very easy to get the section 7 or 9 petition admitted. Certainty of implementation, investors seek certainty that the resolution plan will be implemented effectively without delay and disruption. So that we have already discussed. The professional, it's a good professional practice area to facilitate the implementation of the resolution plan. They expect authorities and stakeholders to support. So we have to put an awareness among the stakeholders. And practically, yeah, see, as an officer of different department, I may not be aware about the IBC process. So if someone can guide them, explain them, adjudicate them, then your work would be very easy for implementing the resolution plan. Profitability, of course, ultimately investor wants return, capital appreciation, dividend, etc. So if the value proposition is there, then investor will definitely come and bid for the acquisitions. Oh, what is the future of the IBC? Future implications of the IBC? Capacity building, as we said, NESL is the only information utility with capacity building, with the information available easily. Reliable information like blockchain technology would be one such option wherein you can trust on the data, you can trust on the databases, etc. So fine, capacity building is taking place in the last 6-7 years. Lot many things have been achieved. IBBI, NCLTs, information utilities. So going forward, more such NESLs kind of information utility would be coming, and the system would be more transparent and easy to access. Infrastructure development, of course, NCLTs. So we do have a good number of NCLTs and benches. As I said, now it is operating at a full strength. But a couple of months back, or I would say last year, people were feeling that NCLT has now become a DRT, but no, NCLT is now adequately staffed, and they do have a good research team as well. So they are doing fantastic job. Orders are getting pronounced very quickly after getting it reserved. Yeah, so we are seeing a good development phase. Adherence to timeline, 14 days timeline is given under the code for admission of the section 7(9) application, which is difficult, not happening, but yeah, it's improving with compulsory recording of default with NESL. The job of the NCLT is becoming easier. So always ensure that the record of the default has to be there with record registered with the NESL. You can always advise your client accordingly. Cross-border insolvency would be another emerging area. Group insolvency, definitely there are some of the matters which have been undertaken under group insolvency, but still the regime is not very clear. So along with time, it will be developed, and so it's a future of the IBC. Monitoring and refinement, jurisprudence development is happening. Behavioral change in the credit culture. We have already seen 26,000 matters getting settled before admission of the CIRP. The CIRP, so best use of the best use of the IBC is not to use at all. So it is always better to have early warning signals, close monitoring, proactive approach, so that a company should not come into the CIRP. So IBC is a good tool, and it actually imparts a behavioral change in the culture of the borrowers. Yeah, procedural streamlining. IBBI is always striving very hard whenever they feel that some provisions are not effective and it is hindering. It come up with a clarification and new policies, new regulation, new processes. So in the last amendment which has came in, so section 92, we were doing section 92 just here and there. We were just putting 3 to 4 mails to the suspended management, and then we were saying that okay, fine, they are not cooperating, and then we were coming with this section 92 application, and oh, fine, I have done my due diligence compliance. So IBBI has changed. See, you have to demonstrate what kind of effort you have put in for taking the custody and control of the corporate data, because as per law it is single line. IRP is supposed to take custody and control of the corporate data, but yeah, it is the toughest thing to do. So why 10 years of experience is required? So that you have to come up with a strategy, you have to explain the legal provisions. By not giving control, what would be the penal provisions, and what ultimately the company corporate data, obviously they would be attached, emotional attachment is there, and they won't be willing to give the control easily. So you have to practically explain them, you have to show a good skill set. And so now the provisions are very clear. After taking the custody and control, you have to designate person for taking care of those assets. So you can always give it back to the ex-management if it's a going concern for you as a practicing professional. If you are not an IPE and you are individual practitioner, you would have a staff of what, 5, 7, 10, 15 people in your firm. Not possible to manage the going concern entity. So you have to rely upon the staff of the corporate data, and you have to give them the official designation and responsibilities through a separate contracts. So yeah, so now within the code, those provisions are there. So though it are 4 to 5, 6 line provision, but it is having a huge impact. So while taking the custody and control, you have to go prepared along with your resources, and immediately you have to make certain lot of decision making for taking custody and giving it back. Cost effectiveness, yes, it is improving. CIRPs were earlier envisaged as very costly solutions, that rather than putting companies into CIRP, bankers were feeling that better to go for the liquidation, and whatever you recover, you take your fees out of the same, but CIRP is a costly affair. But no, now things have been streamlined because of competition, obviously. Now RPs fees, advocates fees, process advisors fees, etc. have been streamlined. Governance, ethics, protection of the interest of the stakeholder, handling complex cases. Yeah, so IBC is there. Though there will be a lot of changes coming in, and as a good practitioner, you have to be well read with respect to the upcoming provisions, and closely monitoring the cases which are running in the NCLT, actually that gives a good perspective with respect to the process involvement. So whenever, if you are based at a location wherein NCLT is there, you should try to visit NCLT and understand what kind of cases are running there, because actually it gives a really good value addition with respect to the process. Because the issue someone is facing, you can avoid that issue in your process. If you know that, okay, fine, doing this will attract so much of issues. Let's not do this and do it this way. Case laws, there are a lot of case laws. I think in many seminars, different case laws are getting discussed. For not going into the case laws. I think now we are left with 20 minutes. Keeping it open for discussion, any queries, questions, suggestion, feedback, we can. मिनिमम 5 क्वेरीज चाहिए सर. Organizers, you can please facilitate unmuting and give opportunity for raising questions, queries. Else,
Sir, is there
Hello.
any
Any questions, please ask.
that NARBCL or debt resolution?
full form बताइए sir.
Debt resolution, I am not remembering that, but NARCL is National Asset Reconstruction Company Limited.
Sir.
Then DIRCL is.
Fine sir, go ahead. Question.
I was asking like, what is the procedure of getting, say, that impaneled there, or is there any process that is there, or it is all larger cases and individualized?
Ultimately, it's current NARCL mandate is acquiring portfolio of more than 500 crore, right? Single exposure more than 500 crore.
Right.
Even in real life situation, if there is an exposure above 500 crore, usually what bank does, bank invites expression of interest from the empaneled insolvency professionals or IPEs, right? And they do have a specific criteria with respect to the experience of resolving similar industry accounts, your resources availability, so and so forth, and your success ratio, etc. So even banks, I tell you, SBI is doing it for even a 10 crore account.
Yeah,
For
yeah.
10 crore account,
Most
yeah,
of the
they are.
banks do that.
Yeah, so of course for NARCL, as you know, and even for a forensic auditor empanelment, you have to have your profile very robust. So you can get in touch with NARCL, you can put up your profile, but yeah, currently they don't have any empanelment mechanism.
Right.
So ultimately what happens, whenever there is any portfolio, they have got their advisory firm and they are taking care of all this support service and all. So usually so they try to have the in-house people, because a lot of talented people are officially employed for doing this activity in-house.
All right.
But of course, they would require RP, because for resolving matter under CIP would require RP. So now, because of this change in regulations, now IPEs are getting appointed as an IRP, RP liquidator, right? So as an individual, nobody would be getting opportunity to get appointed in those accounts. IPE would be appointed as an IRP, RP.
Sure. All right. Thank you.
आप लोग नहीं पूछोगे तो फिर मैं क्वेश्चन पूछूंगा किसी को टारगेट करके. Organizers have given me that liberty. और उनका CPEP फिर इफेक्ट होगा. Right, ma'am?
Sir, I think we should discuss one or two case laws then. Nobody is asking.
मैडम केस लॉ में तो सिर्फ सुनेंगे लोग. एक्चुअली आई वांट सम पार्टिसिपेशन, बिकॉज़ केस लॉज आर देयर. मतलब सब रोज आते हैं आईबीसी लॉ में से, रोज केस लॉ आते हैं ना, सब पढ़ लेते हैं.
Okay.
So
you can then ask.
Madam, sorry, sir, one more question on that. That there was a recent circular or by, I think, IBBI, that they wrote a letter to NCLT that if a resolution, I think CRP is not as successful into a resolution,
yes,
then the resolution professionals will not continue and an alternate RP will be appointed as a liquidator.
yes.
So that is a, mandatory thing, or it is something that is a discretion of the court?
So actually speaking, within the code, it is not mandatory, but there is a provision that IBBI will refer the name. If someone is not giving the consent, or if COC feels that no, they want to change, then so it was a case-to-case basis provision was there. But
Yeah, that
using
was
that
already there,
provision, IBBI has come up with a specific letter. It is not even a
Right.
circular. It is a letter to NCLT.
right.
So they are exercising their power and they are saying that no, fine, based on that letter, now you cannot continue RP and you have to appoint a new liquidator, and all the NCLTs are categorically following that letter.
Okay, are they following it? I mean, I was not aware, that's why I was asking.
Sir, personally, after this July letter, I
Okay,
got replaced in 3 matters, back to back.
okay,
And you would be surprised, 2 matters were filed for liquidation before 1.5 years. It were highly litigated matters.
okay,
So the opposite parties were fighting like anything for not allowing liquidation. And ultimately, when it got allowed, that letter was effective.
okay. Got it.
So many of my lawyer friends says, let us challenge it. It's a ultra virus. Go ahead, yeah, this and that. I said, see, ultimately it is. I cannot go against IBBI
Right.
because we have been governed by IBBI, IPA.
Hmm.
If they are saying, fine, no, you cannot continue, then I can't continue. So it is effectively used. So now what happens usually whenever there is a last COC meeting, in that committee is now deciding that, okay, fine, we would be appointing so and so person as a liquidator. So that no random person would be coming into the process.
Sure.
So that is what now practically all banks are doing.
Okay.
But in a way, yeah, see,
Yeah,
it
it's a
has got
good.
its own pros and cons. See,
It's a
it
pros
is,
and cons
in a
both.
way, it is giving you a pressure that you have to resolve the company. But
Yeah.
the con is that if there are 7-8 litigations are pending, and new liquidator will take 3 to 4 months time to understand the process.
Hmm.
So
Plus, it
practically,
also opens new opportunity for others, right? I mean, those who are
in a way, yeah, it is
not-
giving a new opportunity for others to work, absolutely. But yeah, it will take 3 to 4 months time to
yeah,
understand the
yeah.
process.
Sure.
So as an RP, you know what has happened, legacy was there, so
It's
fine.
much easier.
Yeah, it
much
is much
faster.
easier. Yeah,
Yeah.
yeah, absolutely.
All right.
चलो मैं कोई क्वेश्चन पूछ लेता हूँ. अगर there is a process going on, you are a liquidator and you have funded some companies, intercorporate debts are there, non-related party, then how to recover those debts? If company is into liquidation and you are a liquidator, would you try to recover those money? Or we should not try? What should be the course of
No,
action?
the question is I as a liquidator has funded those company who has a debt in the corporate debtor. Is that
So I am the liquidator, say XYZ Private Limited, and that XYZ Private Limited has given loan to ABC and PQR Private Limited.
right? And in a PQR, I
They are
have
not
no.
related party.
Yeah, then I will certainly try to recover that.
How will you recover? How will you try to recover?
Whatever based on whatever contract or terms and conditions, whatever was there,
So
we
if
have to
so,
file.
there is a debt and there is a default. Do you initiate CIRP against those companies?
Yes, we
That is
do.
allowed
Yes,
or not allowed?
we have. I don't know about the legal, but I have seen 1 or 2 cases which has RP initiating the CRP process. Recently, one of my friend got appointed as RP in those matters.
Right. So technically speaking, it was not allowed prior to 2020.
Okay.
So there was a specific provision wherein if the company is undergoing CRP liquidation, then it cannot initiate CRP liquidation against any other company, so that they wanted to not to have an unlimited pool of the processes. I am suing him, he is suing some other person, like that. Ultimately, the situation arises that in some practical scenario, funds were getting stuck and ultimately company is getting dissolved and they were getting advantage. Okay, fine, company is dissolved, not to pay anyone. So that provision is now there that you can initiate CIRP. However, it requires a prior approval of the NCLT. So you have to demonstrate the case before the NCLT, and based on
Which is
that,
the section, sir? What is this section?
I believe 11A is there, which prohibited earlier. Then there was an explanation. So that section still prohibits, but there is an explanation that this is not applicable to a company which is undergoing CIRP or liquidation. So you, as an RP, I think you can do.
Okay.
So in that case also the threshold limit will be 1 crore?
Absolutely,
Yeah.
sir. Absolutely. You have to. It is normal process. Section 7, you become the financial creditor, and similarly, even if it is an operational debt, it is more than 1 crore, you can initiate as an operational creditor. So as a IRP, RP or liquidator, basically we usually don't focus with respect to the recoveries, but that is one of the most important aspects. So if you demonstrate that there is a recovery possible, you have done enough attempts. So then what happens? Usually you can demand some allocation to those assets by the resolution applicant. Because ultimately, as a resolution professional, our target is to get the value maximization. So, and as a compliance officer also, you should write letter to all the debtors and try to recover the money. And I have seen practically monies are getting recovered. Ultimately, if you want to settle, you can always put up a proposition before the COC. See, fine, this guy is ready to pay me 30 rupees out of 100 rupees. Would you like to settle the case? If COC says fine, then settle it. So, though under the code, we have to do lot of compliances, and doing compliances takes lot of time. And because of that, we are not focusing on the practical aspects of how to get a good resolution plan. So, as I said, it's a full-time profession, so you required a specialized team. So a team should be expert in the compliances. They will be doing the compliances, and you, as an IRP, RP, or liquidator, you are supposed to be a strategist, and ultimately how to deal with the ex-management, how to get work out from them, and how to scout for the resolution applicants and doing the complete due diligence. Along with that, managing the litigations. That is your major role. So don't. I am not saying that don't do compliance. Compliances are essential, because the day IBBI is initiating the inspection or the IPA is initiating inspection, they will ask for the record which you won't believe that you have created. So they will ask for the unlimited records. So you have to be compliant, but have a dedicated team who will be doing compliances for you, because at your level, you are not supposed to do these basic compliances and all. Your team should be doing it, and you should focus on the getting a resolution. Because ultimately, for me, if I am able to successfully completing the process, it is the biggest opportunity that I will be getting new matters. If in my profile I say I have managed 7 matters, of which 6 went into liquidation, so no bank would be preferring my services, because liquidation is an automated process. Not doing nothing, ultimately company would be going into liquidation. If you can demonstrate, no, you have an expertise and you have completed the resolutions, then definitely it will give a good rapport with the bank. It will create a good goodwill, and ultimately you as a professional will grow. So my suggestion to all fellow insolvency professionals, that give your best whenever you get appointed. Even if you are appointed as an IRP under Section 9 application, don't wait that after 1 month, if I am getting confirmed as an IRP, then I will be doing so. See, if you are not doing anything, just you have collected a claim, then in first COC meeting, you won't be able to demonstrate that what all activities you have done, and you are the only person who should be continued as an RP. And though banks, even in SBI, I have seen that though they have got a policy that they deploy only empaneled professional as an RP, there are exceptions. I have seen exceptions as well. IRP doing good stuff, good work, they continue them as an RP. So do your best. Don't bother about the fees. Ultimately, when you are giving consent to be there on the panel of the NCLT, at that time, you are not saying that, okay, fine, without fee, I won't be working. And now the minimum fee criteria are there. Ultimately, if you have done a good job, you will get a fees. Yeah. Any business require working capital investment. So as a professional, you also would require some working capital investment. So you have to incur certain costs. As I said, if factory is not in a operation condition, see, at least you can get it clean. You can put 3 to 4 workers and you can get it clean. So all those stuff though require time, energy, cost, investment, but it will eventually pay you. So the code is actually a basic thing. Code says minimum you have to do, but it never restrict in the true spirit. Based on that, you can go whatever you want to do to maximize the interest of the stakeholders. So that's it from my side. Thank you so much for patience hearing. Topic थोड़ा था ऐसा कि जो थोड़ा डिफिकल्ट होता पार्टिसिपेंट के लिए सुनना, बट मैं मान लेता हूँ कि everyone has been there throughout the session, though videos were off. I feel that everyone was there. So thank you so much. Over
Thank
to
you,
you,
Jigar
Naveen.
Bhatt. Thank you very much.
Thank you, sir.
It was a very good learning.
Thank you, sir.
Thank you, sir. Thank you so much. And
Sir,
yeah,
I would just call you because I wanted to understand a few things, especially from the perspective of the representation in the NCLT, which you said. Because as you said that, as a RP, presenting your case is always better.
yes,
Because, sir, your experience will be of NCLT Ahmedabad, or have you also experienced NCLT Mumbai?
I do have experience of NCD Mumbai, sir.
Acha, okay. Because, sometimes it also happens like, the face value also matters in some of the cases.
Absolutely. Face value matters. So that is the reason you have to be there frequently. So they will recognize you. See, obviously, twice, thrice, 4 times, they won't give you enough of attention.
Right.
But if you are clear with respect to your thought process, थोड़ा मिलॉट्स बोलना ट्रेन करना पड़ेगा अपने आप को, बट सी थॉट प्रोसेस अगर क्लियर है ना तो दे विल डेफिनेटली गिव यू इम्पोर्टेंस.
Right. Because abhi kya ho raha hai? I mean, as far as the CRP and liquidation cases are concerned, I mean, the fees and everything is still fine. But when we talk about personal guarantee cases, the fee is always a challenge. So in such kind of cases, representing before the NCLT, I think it should be preferred. Because for every petition or every IA, putting some lawyer for representation, in place of that, if the RP is given, does that representation, that will be better for him.
Certainly, and actually, so I have seen even in Mumbai NCLT that they prefer whenever you file Section 99 IA, they
Yeah.
always ask where is the RP, because
Right.
ultimately Section 99 is all about claim verification.
Right.
Most of the hearings, sir, I think NCLT
So if
Mumbai.
they will always ask if whosoever, because in CIRP you cannot delegate your work. Claim verification cannot be delegated. Section 99 is basically claim verification. So
Right.
you have to do it and you have to represent before the NCLT.
Right.
Yeah, certainly. And I always recommend bankers that whenever there is a matter, now you should send your officer as well, because sometimes some queries are there that advocate won't be able to answer, or as an RP you won't be able to answer because you are not their agent or you are not there. If there is a resolution plan application and if NCLT doubts the eligibility or the capability of the resolution applicant, at max you can say this is the net worth statement, these are the liquid funds. But ultimately, bank has to push that we have done a due diligence, it is our commercial wisdom, because as an RP you cannot say. So if you want to have a quick resolution, then managing NCLT process being there, that is must, because that is something which RPs are not regularly doing.
Right.
Fine. So thank you so much. Thank you all.
Thank you very much. It was a very good session. Thanks. Thank you a lot. Thanks a lot.
Thank you,
Thank
Abhijit.
you very much, sir, for giving your valuable time and addressing session on the topic and making the session very learningful and interactive. Sir, you are requested to share your 15s with us.
Requested this PPT.
Yes, sir, this
हाँ
presentation.
श्योर, थोड़ी एफर्ट्स की है तो कुछ लोग पढ़ेंगे तो आई वुड बी मोर देन हैप्पी.
So
आई
you
विल
can share it
सर्टेनली.
with me. I will forward it to participants.
Sure मैम, श्योर, सर्टेनली. फाइन, चलो, थैंक यू, बाय बाय.
Thank you very much, sir.